Yeah, please, Your Lordship. Lordship, as per office note dated 13/5/26, LCR is awaited. Reminder may be issued.
Service completed?
Yes, Lordship. Respondent number 1 has entered appearance.
Heard, miss?
Yes.
Learned counsel for the appellant, none appears for the respondent on call. Office note dated 13/5/2026 indicates that LCR is awaited. Recessal is so urgent reminder for transmitting to the learned tribunal for transmitting the record. Place the matter immediately after receiving the record from the learned tribunal.
Item 10. Item 10.
None appears for the appellant on call. Place the matter after a week. In the event of subsequent non-representation, appropriate orders will follow.
Item 11.
In this case, we were required to find one affidavit of affecting service on trustee by trustee on respondent number 2. We have given the documents to the office, but we have no instruction as to whether it is submitted, it is already served or not. So we are not in a position to file the affidavit, Lordship. So I prefer some time, Lordship. We have to
Okay,
take it
Mr. Soikia, learned counsel for the appellant, pressed for granting him some time to file the affidavit after effecting service upon respondent number 2. Pair allowed, recessal is the matter after a week.
Lordship, after vacation.
After vacation.
Obliged.
Item 12.
Yeah, please. Notice was served through paper publication, Your Lordship. So, yeah, as per the order of this court, so the affidavit has been filed, Your Lordship.
This I is for?
I is for delay condonation. Delay condonation of 45 days, Your Lordship.
How many days?
45 days. In this case, what happened, Your Lordship? Earlier, we have filed that appeal in time, but there is some technical defect. Because of that, we have withdrawn the case, and accordingly, there is a delay of 45 days, Your Lordship.
Heard. Mr. Upadhyay, learned counsel for the applicant. Mr. Upadhyay submits that after effecting service of notice upon the respondent by substituted mode, certificate paper publication, an affidavit has been filed by the applicant. And it appears that the notice was published in which paper it was published?
Yes.
In the Ohomia Proceedings daily newspaper.
Assamia Proceedings.
On 10th of February 2026. But the respondent remain unrepresented today. In that way of the matter, notice deemed to have been served. But the respondent remain unrepresented today. This interlocutory application is prepared by the applicant for condonation of delay of 45 days in preferring connected appeal against the judgment and order dated 12/12/2022 passed by the learned Additional District Judge FTC Dibrugarh, whereby title suit written with a D number 128 of 2018 filed by the respondent under section 13(1)(a) was allowed on contest. What is the grounds for delay?
Yes, your lordship, there are four, your lordship. There are 4 and 5. It's because we have filed earlier met appeal in time, but it was listed after 1 month.
Mr. Upadhyay, learned counsel for the applicant, referring to paragraph number 4 and 5 of the application, submits that earlier the appeal was filed in time, but due to some defect, the same was not listed before the court.
It was registered as met appeal 17, 2023.
And that the delay is not intentional, or rather it is circumstantial, and under such circumstances, he is contended to condone the delay of 45 days in preparing the connected matrimonial appeal under section 19 of the Family Court Act. Read with section 96 of the Code of Civil Procedure. Having heard the submission of Mr. Upadhyay, learned counsel for the applicant, this court has carefully gone through the application and the documents plus in record. And it appears from the explanation so put forwarded in paragraph number 4 and 5 of the application that the delay is sufficiently explained. And as such, the same is since condoned. In view of the order passed in the interlocutory application, now the registrar shall register the appeal and list the same before the court as soon as practicable. In terms of this higher distance disposal.
Item 13.
Make this letter. We should file an objection against the confirmation application. The petitioner checked with the record. Submitted the expectations. Witness. And then put the objection.
When did you file?
Yesterday.
Okay. Okay. Yes, file objection. It is not lesson record. Call it timing.
Item 40.
None appears for the applicant on call. List the matter after a week. In the event of subsequent non-representation of the applicant, the appropriate orders will follow.
Item 50. 40.
14 will take.
I'm sorry. I'm 14.
Later on, Mr. P. Hazarika, learned counsel for the applicant, present.
May I present?
This I is for
I ask for a condolation of delay of 430 days, my lord.
whether notice was served.
Notice was served, my lord, on the 29/4/2024. They appeared and from them they have taken time for filing the objection.
Yes,
Almost-
any objection?
Lordship, here I am appearing for respondent number 3 and 4. I would like to withdraw my name from respondent number 4, Lordship, because the claimant and the owner are the same party, and I cannot appear for both the parties. By mistake, I have filed Wakanda in both the case, both the respondents, Lordship. So I'd like to withdraw from respondent number 4, Lordship. My name from respondent number.
And later on, miss, your name, please.
P. Varga, Lordship.
Learned counsel appeared on behalf of respondent number 1 and
1, 2, and 3, I'm appearing, Lordship. For 4, I'm withdrawing my name.
1, 2, 3, and 4. However, she submits that she has withdrawn her galatnama in respect of respondent number 4. You have objection in condoning the delay?
Lordship, yes, I have objection for 30 days. Lordship, it's not a short period.
But you
Lordship will find
see,
order dated 29/4/2024.
since you have withdrawn,
They have taken time.
we have to issue registry shall issue notice to the respondent number 4.
Now, my lord.
Since Ms. Borua has withdrawn her kalatnama in respect of respondent number 4, the registry shall issue notice to the respondent number 4 are returnable after 3 weeks. List the matter after 3 weeks.
In the meantime, they will file their objection
We
immediately.
file our objection.
In the meantime, the respondent number 1, 2, and 3 may file their
Well,
objection if so
Public.
advised.
Item 15.
None appears for the appellant on call. List the matter after a week. In the event of subsequent non-representation, appropriate order shall follow.
16.
May I, Your Lordship?
Hmm.
Lordship, in this case, I have challenged the degree of divorce, Lordship. And
TCR was called for on last.
Service completed.
TCR is there, Lordship.
So we may fix the matter for hearing then.
Yes, madam. In the meantime, my lord, we bring some documents, my lord. After the lapse of appeal period, my lord, the respondent has married again. Out of their case of wedlock, my lord, he just with the daily card. I will be placing all these records to an affidavit, my lord, before this honorable court.
Ah,
Yes.
Lordship, kindly fix this matter before vacation, Lordship, kindly. Because this is an ex parte order, Lordship.
okay.
And my
Heard.
learned friend also taking time, Lordship, for filing this affidavit.
But
But they have not filed, Lordship.
Heard Mr. Mazumdar, learned counsel for the appellant, and Mr. Sodhuri for the respondent. It is submitted at the bar that service in this matter has been completed and the LCR has also been received, and in that way of the matter, under such circumstances, it is contended to place the matter for hearing. Mr. Mazumdar, learned counsel for the appellant, submits that this appeal is preferred against one ex parte order,
Yes, Lord.
and as such, he has insisted upon fixing the matter before vacation. Pair allowed, versus list the matter before vacation.
Can it be after
Daily.
hearing matter, my lord? It takes some time, kindly, my lord.
Lordship,
Will be required, my lord.
24, 23 matter, Lordship. And getting pendency of this case, Lordship, they are taking chance, Lordship.
No, Mr. Sodhuri, you say the vacation will start from 27th.
Yes, Lord.
Yes, ma'am.
Before any vacation.
Before vacation, you
Yes, sir.
file your affidavit.
53.
Well,
Item 17.
It will not allocate it. Mr. Sodhuri also apprised this court that the appellant hearing after the order being passed got married, and he will bring the said fact on record by filing parallel.
May please, Lordship, wait for, respond number 1, I took the state. That who has appeared, owner of the vehicle, one is the claimant. So, my lord, I have not find this address, but address I mentioned herein, the claimant himself address in the claim petition. So maybe a further time may be allowed, 15 days may be allowed. Because one is the claimant, respond number 1. The claimant, the address is mentioned in the claim petition. According to that, I have mentioned here, I took step also. So last occasion, I took time for correction of the address or to find out.
Mr. R.C. Pal, learned counsel for the appellant, and Miss
M. Gogoi.
M.
Two,
Gogoi,
for
learned
respondent
counsel
number
for the respondent number 2. Respondent number 2. Office note dated 26/5/2025 indicates that no step for service of notice upon respondent number was taken through usual process. In that way of the matter, the appellant herein is directed to take step upon the respondent number 1 by usual process. Person to order of this court dated 5/2/2025.
My lord, I'll take the easier process.
List after 4 weeks.
My lord, Mathur.
Item 18.
As per official, both the respondent has refused to accept the notice.
Heard Mr. K.K. Bhatta, learned counsel for the appellant. Office note dated 5/5/2025. Indicates that respondent number 1 refused to accept the notice. In that view of the matter, notice deemed to have been served upon the respondent number 1. Office note dated 28/2/2025 indicates that neither ID card nor answer notice issued to the respondent number 2 has been received back by the registrar. Accordingly, it is provided that the appellant shall take fresh step upon the respondent number 2 by speed post and also by
Respondent
legal
number 2
process.
also
which
lordship.
will come today.
Regarding respondent number 2 also, lordship, kindly flag mark A and B. Lordship, he also refused to accept the notice.
No, the office note is silent in respect of refusal by the respondent number 2.
But he in earlier order, lordship, it has been shown that service on regarding respondent number 2, he has refused to accept notice.
You see the office note? Take place is the list after 4 weeks.
Item 19.
To flag bit go to listen. You are for the respondent. Appellant is absent. Appellant is absent.
Absent today.
None appears for the appellant on call. However, Mr. Ganguly, learned counsel for the respondent present. List the matter after 2 weeks. In the event of subsequent non-representation of the appellant, appropriate orders will follow.
That is from after the reclosure. After the reclosure.
After a week.
Item 20.
Lordship, in this case, my learned friend has appeared for the respondent number 1 to 3. And appeal has not admitted till now, lordship. Notice was issued, lordship. And a lower court record has come.
But if we admit the appeal, lordship, and 50% may be
Lordship,
because lordship. Okay. What?
lordship, in this case, lordship, as per the initial GT entry, one unknown vehicle was involved in the accident. Subsequently, lordship, after 1 month, FIR was filed showing the name of one vehicle, lordship. But there is some anomaly in the subsequent GT entry. Lordship, as per the subsequent GT entry number, lordship,
No,
it was,
Mr. Bhatt, we will consider the same at the time of hearing, not at this instance.
And Lordship, I would like to submit something, Lordship, in an analogous case, that is MSC case number 25221. He was the rider of the motorcycle. The compensation has been paid. They have taken appeal in that case. In the injury case, they have made the payment of 2,08,109 along with interest. So it can be admitted, Lordship.
Heard Mr. Bhatt, learned counsel for the appellant, Ms. Majumdar for the respondent number 1 to 3. How many respondents are here?
5 respondents is there, 1 to 3, my learned friends has appeared.
1, 2, 3.
Nikki?
It is submitted at the bar that though notice was issued earlier, the appeal has not yet been admitted.
He signed for another document.
Accordingly, a contention is being made that the appeal may be admitted and notice may be issued to the rest of the respondent.
Lordship, already I have taken step, Lordship, 456.
That is long back. This appeal under section 173 is directed against the judgment and award dated 6/7/2024 passed by the learned member Motor Accident Claim Tribunal Barpeta in MSC case number 251 of 2021. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees 16,73,000 with interest at the rate of 60% per annum from the date of filing of evidence and affidavit till final payment. Final payment. Where is the memo of appeal and the grounds mentioned therein? Let notice be issued to the respondent returnable in admit. Issue notice to the respondent returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, and 3 since Ms. Majumdar has entered appearance and received notice. Step upon rest of the respondent be taken by speed post and also by usual process within or from today. Yes, shall call for the record from the learned tribunal list after 4 weeks. I is for stay.
Lordship,
Heard Mr. Bhatt, learned counsel for the appellant, and also Ms. Majumdar, learned counsel for the respondent opposite party number 123. This interlocutory application is prepared by the appellant for staying operation of the judgment and award dated 6/7/2024 passed in MSC case number 251 of 2021 by the member Motor Accident Claim Tribunal Barpeta. Mr. Bhatt submits that connected appeal has already been admitted for hearing and the record has been called. And as such, there is a requirement of staying operation of the impugned judgment and award till disposal of the appeal. Ms. Majumdar, learned counsel for the respondent opposite party number 1 to 3 submits that the impugned judgment and award may be stayed subject to depositing 50% of the awarded amount before the registry of this court. The submission of learned counsel for both the parties receive due consideration of this court, and taking note of the same, and also considering the facts and circumstances on the record, it is provided that the impugned judgment and order award dated so and so be stayed, subject however to depositing 50% of the awarded amount before the registry of this court. And on such deposit being made before the registry of this court within a period of 4 weeks from today, the opposite party shall be at liberty to withdraw the same, subject however to furnishing one bond.
It won't, they are poor people, Lordship. Even if they give a bond, I don't know.
No, the stand here, no, he has taken a stand, therefore.
that's
Lordship, that's the respondent number
3 is a minor lordship, so 1 and 2 can withdraw. Or
Okay, Ms. Mazumdar has pointed out that respondent number 3 is minor. And as such, he will be represented by respondent number 2. 1.
mother.
Maybe, let me go. I'm the respondent, petitioner in person. I may be allowed to make an objection.
Reply.
Yes. Yes.
This I is for continuation of delay.
Lord. 99 days. 99 days delay.
90,
99.
99 days.
Or has been filed.
Mr. Fokon comments that he may be granted some time to file objection. They are allowed list the matter after vacation.
So one thing, I filed one additional affidavit. Copy of that hasn't been served to my learned friend. So I'm giving it today itself, and that may be recorded, Lordship.
No, that affidavit is in connection with.
In connection with the IA for continuation of delay. Actually, one application was filed before the registry of this honorable court for not furnishing the copy of the.
Mr. Sharma further submits that he has also filed one additional affidavit. When did you file?
I filed it earlier, so it is in the record, Lordship. I
And-
filed it on 13/12/24.
He has served a copy of the same to the petitioner in person. Accordingly, it is provided that registry shall take the affidavit with this I and list after vacation.
22.
Obliged, Lordship.
In this case, service on respondent number 3 may be waived, he may be struck off. Lordship.
The other two?
Other two lordship hasn't served, Lordship. Only 3 lordship.
Art Mr. Goswami, learned counsel for the applicant. Office note dated 21/5/2026 indicates that service report in respect of respondent number 3 is still awaited. Mr. Goswami, learned counsel for the applicant, submits that the name of respondent opposite party number 3 may be struck off from the array of this application. Accordingly, taking note of the submission of Mr. Goswami, learned counsel for the applicant, it is provided that the name of respondent opposite party number 3 be struck off from the array of this application at the cost and risks of the application. List the matter in the next week.
Yes, Lordship, next week. The delay condition petition will be heard.
This is a list this I on.
Obliged.
17.
70.
Item 23.
May it pleases your lordship. Lordship, as per office note dated 14/11/25, lordship, for respondent number 2, process server has given the report that no such person like Abdul Ali couldn't be traced out. Lordship, we may take a speed post steps because usual process was taken, lordship.
Mr. Biswas, you are for
And for the respondent number 1, your lordship.
respondent number 1. Art Ms. Mazumdar, learned
Payment.
counsel for the applicant. Mr. Biswas for the respondent number 1. Office note dated 14/11/2025 indicates that as per report of the process server, respondent number 2 could not be found out. Ms. Mazumdar submits that she may be allowed to take fresh step upon the respondent number 2 by speed post. They are allowed. Step be taken within a week from today, list after 4 weeks.
Date week after vacation because payment, we are awaiting, if it is admitted also some part, we will get at least the date. Maybe
Lordship, delay has to be condoned. I do not mind 50%.
No,
But-
delay is there, I have objections with that, so a date may be fixed, Your Lordship, because it's.
After 4 weeks.
20 July. I do apologize. I said 24.
Wait, Peter. What if this matrimonial appeal has been filed challenging the order of permanent alimony? I am for the appellant husband, not with. In this case, the wife has income of the wife is around approx 65,000. The husband is around 40,000. PCR is before your lordship. Lordship may.
You can see the last order, Lordship.
No, this, no, madam, this IA is for?
IA is for suspension, for stay of the operation of the impugno. In that case, till date, there is no order. In terms of the last order, we have deposited the amount from January 2024 to October 2024. Since the matter was listed in the month of October 2024, and the order is of January 2024. So we have paid the amount from January to October 2024 in terms of the order of the Honorable Court. Now, Lordship, in this case, the husband is also remarried, Lordship, and this matter may be given a quieter source.
For the appellant and Miss P. Bottas as the learned counsel for the respondent. Raises leaves this matter for final hearing immediately after reopening of the vacation.
Yes, Lordship, can I fix a date, Lordship?
On
Yes, Lordship. Upright, Lordship.
along with the IA bill number 2400/2024. Oh, and on that day, an endeavor will be made to finally dispose of the matter. Okay.
Item 25.
So this is a delay condonation petition, not a delay of 55 days. Service is already complete.
Yes, any objection? No objection. Heard Mr. Soikia, learned counsel for the applicant, and Mr. N.J. Chaudhary, learned counsel for the respondent. Respondent number 1. Mr. Soikia has pointed out that service in this matter has been completed and that this interlocutory application is referred for condonation of delay of
55 days, Lordship.
55 days in preferring connected MSc appeal against the judgment and award dated 27/5/2024 passed by the learned member Motor Accident Claim Tribunal Nagaon in MSc case number 22 of 2019. What is the ground?
Lordship, explanation paragraph 4, Lordship. Judgment was delivered on 27/5, certified copy was received on 7/6, Lordship. And then some official procedures were undertaken, legal opinion was obtained from. High
Mr.
Court.
Soikia, learned counsel for the applicant submits that though the judgment was delivered on 27/5/2024, yet the certified copy of the said judgment was received only on 7/6/2024, and thereafter the applicant herein has required to observe some formality such as obtaining legal opinion and in the process delay of 45 days occurred. No, 55 days occurred, and the same is not intentional, rather it is circumstantial. And under such circumstances, he has contended to condone the same. Mr. Chaudhary, learned counsel for the respondent opposite party number so and so submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations so put forwarded for the delay of 55 days, this court is of the view that the delay is sufficiently explained, and accordingly, the same is thence condoned. In terms of above, this IA is thence disposed of, and in view of the order passed in the IA, now the restee will register the appeal and list the same before the court as soon as practicable.
26.
Please, Lordship. Service on respondent number 1, 2, and 3 is complete. We have also deposited the 50% of the awarded amount. Lordship, the matter may be fixed for final hearing.
Heard, miss?
P. Fukan on behalf of PJ Burman.
And also heard, miss?
K. Bora for respondent 1 and 2.
K. Bora, learned counsel for the respondent number 1 and 2.
Lordship, I appear for respondent number 3, Lordship. We have filed an affidavit, Lordship. In the month of April, in the respective I check it today, Lordship.
Mr. Bhagavati for respondent number 3.
For 3.
Respondent number
I think
3.
that is not on the record, Lordship.
It is submitted at the bar that service in this matter has been completed. LCR received?
No, Lordship.
Huh?
Yeah, not received. Not received, Lordship.
An office note dated 13/3/2026 indicates that LCR has not been received. Accordingly, it is provided that Registrar shall issue urgent reminder to the learned court below for transmitting the record. Mr. Bhagavati submits that he has filed one affidavit.
Lordship.
When? The month of April, and the same has not been placed on record. And accordingly, it is provided that Registrar shall take the affidavit filed by the respondent number 3 with the record and list the matter immediately after receiving the record from the learned tribunal.
Oblige, Your Lordship.
Numbers 29 and 30.
The commissioner, not tribunal, commissioner.
59. Well, in this both the items, my lord, 29 and 30, my lord. Service upon respondent number 1, 2, 3 completed, my lord. Upon 4, my lord, still awaited.
4.
4. Both the items, my lord. And PCR also not received, my lord.
Heard Mr. Das, learned counsel for the appellant, and Mr. Mokit for
For respondent number 1, 2, and 3.
respondent number 1, 2, and 3. Office not dated. There is no office note in respect
Office
of
note in
respondent
item
number
number
4.
30 is there. In item number 30, there is the office note. But regarding, my lord, service report, none of the office note reflects anything about the service report, my lord, about respondent number 3.
It was section of.
It simply says that we took steps upon all the respondents.
Office.
1, 2, 3.
Ito na.
Section of
Section of permanent.
and section of permanent. Section of similar.
Bench over another.
Even next to the last sentence, we have this too.
Mr. Das, learned counsel for the appellant, has pointed out that a service in respect of respondent number 4 is still awaited, and the office note are also silent in both the RFA number 65 and 2025 and RFA number 76 of 2025. And he also pointed it out that the PCR has also not been received. What to do? You want to take fresh step upon respondent number 4?
Lord, may await service, my lord, upon respondent number 4.
Registrar list the matter after 2 weeks, awaiting service report upon respondent number 4, and shall also issue urgent reminder to the learned trial court for
Civil judge.
transmitting the record of title suit number 54 of 2014.
What?
List after 2 weeks.
In both the
Registrar
items.
also put up one up-to-date office note in respect of service of notice upon respondent number 4 after taking the same in the departmental website.
But same order for both the items, no? Same order for both the items. Highly obvious.
31.
Losses, I am for the respondent number 1, 2, 3, 5, and 6. And now I have filed on the IA. I have for interim order to release the 50% of the awarded amount.
Is it deposited
But
before?
the appeal already been admitted without being heard the respondent side. So that's I have lordships. But this honorable court has ample power to pass award for release of 50% of the awarded amount.
No, whether the order was stayed.
Lordship, this was, the direction was, there's no direction for depositing the amount because I had sold the liability. But no, I'll.
Without being heard, finally admitted.
The admission is not like that. Lordship.
No, is there any requirement of hearing the respondent at the time of admission of the first appeal? Is there?
Lordships, LCR have been received and all service completed. As per the office note
Okay,
of
you take down. Hard Mr. Your name, please.
26.
Your name,
S.C. Pandit.
learned counsel for the applicant and Mr. Goswami for the respondent. This interlocutory application is preferred by the applicant for issuing direction to the appellant. Stroke opposite party hearing for depositing 50%. No, for issuing direction to deposit 50% of the awarded amount before the registry of this court. Mr. Pandit has pointed out that the impugned judgment and order dated 16/9/2025 was stayed in the IA civil number 3819 of 2025 without issuing any direction to the respondent opposite party to deposit 50% of the awarded amount. And under such circumstances, he has contended to issue direction to the respondent opposite party to deposit 50% of the awarded amount before the registry of this court. Mr. Goswami, you deposit 50% of the. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that 50% of the awarded amount shall be deposited before the registry of this court within a period of 4 weeks from today. And on such deposit being made, the same shall be released in favor of the applicant after proper identification.
Lordship, I have
Yes.
just one small query, Lordship. Since I'm selling the liability, let him produce subject to furnishing a
Okay.
amount.
Subject, however, to furnishing a bond. Bond. In terms of this IA disposal, in this appeal is ready for hearing.
Yes.
Heard, Mr. Goswami, learned counsel for the appellant, and Mr. Pandit for the respondent. Respondent number
1, 2, 3, 5, 6.
1, 2, 3, 5, 6. What happened about respondent number 4?
That is owner of the vehicle, offending vehicle, and he has been received a notice, and here, as per office note 13/5/2026, and case mark is R. Consignment track consignment.
And the LCR has also been received. In that view of the matter, registrar shall list the matter after vacation for final hearing.
Yes.
All right.
Item 32.
Actually, Your Worship, on the last date, Your Honor has directed us to take steps upon the defense number 1 and 2, respond number 1 and 2, but we have not been able to take steps. We'll
Okay.
take the
Heard-
steps today only.
Heard, Mr. Your name, please?
R.A. Lahokar.
R.A. Locker, Learned Counsel for the Appellant. Learned Counsel for the Appellant submits that though there was a direction of this court to take step upon respondent number 1 and 2, yet the said step could not be taken, and he pressed for allowing some time to take the same again. Accordingly, it is provided that step upon respondent number 1 and 2 be taken by speed post and also by usual process within a week from today. List after for weeks.
Obliges.
33.
Maybe please, your lordship, that time will be passable for time being, lordship. 34 also similar law. 34 also.
35.
Lordship, in this case, the policy was brought on record by the owner. But the insurers failed to formally prove the policy and lead evidence regarding the nature and extent of coverage. let's say. So the tribunal did not examine whether any additional premium was paid for a labor attached to the claim. Lordship. So that is why we seek permission to adduce evidence only to proving the terms and coverage of the policy. The policy is on the part of the record.
No,
The
if the policy was produced before the court at the time of hearing,
The policy was produced by the owner along with the photocopy of the policy was produced by the owner.
no, is there any dispute about the policy?
Yes, let's say.
How?
The policy was not disputed, let's say.
Then
Extent of coverage was disputed. Let's say. There is no coverage for the helper, let's say. Only there was coverage for the driver.
yes.
In the WS, insurance has admitted the policy. It is covered. And IMT 150 rupees was paid per person 50, my lord. That is the IMT.
No, the policy was for how many persons?
3 persons
3
for
persons.
IMT. Indian motor trade 50 rupees is my lord. Driver, helper, and cleaner. And they have duly cross-examined the owner, my lord. And they did not put any question in this, and they have not disputed, my lord. And moreover, my lord, they have admitted in the WS, my lord, that it is covered. WS is my lord. That's 35, my lord.
LCR has been received.
No,
LCR is not done. So
Not
what the case may be finally yet after receiving the LCR, let's say.
my lord.
If that was covered, let's say, that is,
Well,
but there is no coverage, let's say, only
owner has adduced evidence, my lord. They have duly cross-examined. And
No, this application we cannot consider at this stage. It can only be considered at the time of hearing.
let's see. This
Hearing of the
this
appeal, yes.
application may be considered at the time of hearing, let's say.
Is the main appeal ready for hearing?
Main appeal is admitted, let's say. Appeal is admitted, let's say, LCR has not come.
Madam, for is 50%.
Service is completed, let's say.
It's covered. And there is a special judgment of the this helper is included.
It is a can, let's say. There is no.
No. Is there any pair for staying the impugn order?
There is a I pending, madam.
I for the stay, let's say.
There is a 2 I, 1 is pending, madam. Today is done, madam. Still.
A point my friend is raising, that can be hard at the time of paying, but for stay, 50% will be deposition. It is not payment.
Okay, take down. Hard. Mr. KK Bhatt, learned counsel for the applicant. And Mr. Learned counsel for the respondent.
Respondent 1 to 5.
Respondent number 1 to 5.
That's about my friend.
Mr. Gogoi for respondent number 6 to 7. This interlocutory application under Order 41, Rule 27 of the Code of Civil Procedure is preferred by the applicant to adduce additional evidence and documents in connected appeal. Let this application be considered at the time of hearing of the appeal. And also heard Mr. KK Bhatt, learned counsel for the applicant, and Mr. Gokoliel for the respondent number 1 to 5, Mr. Gogor for respondent number 6 and 7. This interlocutory application is referred by the applicant for staying operation of the impugned judgment in award dated 9/1/2024. Passed by the learned member, Motor Accident Claim Tribunal, Dibrugarh in MSC case number 43 of 2022. After hearing learned counsel for both the parties and also taking note of the fact that the connected appeal has already been admitted for hearing and the record has been called for. Operation of the impugned judgment and award dated so state subject, however, to depositing 50% of the awarded amount before the registry of this court within a period of 4 weeks from today. In terms of this I instance disposal. And on such deposit being made before the registry of this court, the respondent shall be at liberty to withdraw the same. After furnishing relevant document for identification.
Number 36.
May it please your lordship. As per
main case party लिख देगा and since service has been completed and LCR has been received, the matter may be listed for admission, no, for final hearing of vacation. Or SSL is urgent reminder for transmitting to the learned tribunal for transmitting the record without further delay. List after 4 weeks. Yes, madam.
lordship, as per office note dated 6/6/26, service report of our respondent 2 has not been received and TCR received. So we have to await lordship for service.
No, in respect of other respondent,
Mr. Padgiri is appearing.
Padgiri for respondent number 1.
Yes.
Heard Ms. Mojumdar, learned counsel for the appellant, Mr. Padgiri for the respondent number 1. How many respondents are here?
2, lordship.
Office note dated 6/6/2026 indicates that service report in respect of respondent number 2 is still awaited. LCR has been received?
Yes, lordship. Same office note, lordship. Down
The
below.
said office note also indicates that LCR has been received. Accordingly, it is provided that rest is release the matter after 2 weeks, awaiting service report upon respondent number 2.
Highly obliged.
Item 37.
May I please your lordship, as per office note dated 8/6/26, LCR yet not received. Interim order may continue.
Respondent key. Art Miss, your name please?
B Sarkar.
Learned counsel for the appellant, none appears for the respondent number. No,
Sole
none appeared for the respondent on call. Office note dated 8/6/2026 indicates that no TCR has been received. Accordingly, it is provided that receipt shall issue urgent reminder to the learned trial court for transmitting the record. Interim order passed in the I number 716 of 2026 shall continue.
Highly authorized.
Item 38.
May I please, your lordship? Your lordship, in this matter, respondent number 1, 4, 5, and 6. Earlier they have appeared, your lordship. And as
1,
regard
4?
to 1, 4, 5, and 6.
They have appeared.
Yes, your lordship.
You are representing 1, 4?
Respondent number 1.
1.
1.
Only 1.
Only 1.
Okay. Who represent the other respondent?
As per cause list, Miss R. A. Chaudhary is appearing.
RS Chaudhary. Then in respect of respondent number 3?
2, 3, and 7. Notice was served, your lordship. As per office note dated 10/3/26 and 4/2/26.
Service completed.
It is not mentioned in the office note, your lordship. Only the steps taken and the sent through the speed post is mentioned.
Thank you.
27.
Okay. Third Mr.
R. A. Mazumdar.
R. A. Mazumdar, learned counsel for the this IH for
I is for stay, your lordship. Stay has been granted.
granted.
Yes, sir. As per last words.
Learned counsel for the appellant and Mr.
S.H.
S.H. Rahman, learned counsel for the respondent number 1. Respondent number 1. In view of the office note dated 27/3/2026, service in respect of respondent number 2, 4, 5, 6, and 7 stands completed. The said office note also indicates that notice could not be, no, service of notice upon respondent number 3 could not be effected due to mismatch of the title. Accordingly, learned counsel for the appellant is directed to obtain instruction and to take fresh step upon respondent number 4. No, sorry, respondent number 3 by speed post and also by usual process within a week from today. Mismatch of title.
Yes, sir.
You obtain instruction
Yes, sir.
and take fresh step. The said office note also indicates that TCR has not yet been received. Receipt shall issue urgent reminder to the learned trial court for transmitting the record. List the matter after 4 weeks.
Interim may be continued.
Interim order passed in the IA number 100 of 2026 shall continue.
Obliged.
Item 39.
May it pleases your lordship. This is listed for the first time. This is a delay petition, lordship. Delay of 57 days, lordship. Notice will go, lordship.
Heard Miss Mazumdar, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay Of how many days?
57.
57 days in preferring connected appeal against the judgment and award passed by the learned commissioner. Employees compensation Borpeta in WC case number 3 of 2023. Let notice be issued to the respondent opposite party returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Highly object.
Item 40.
May I please Lassi, is a delay condemnation petition. How many days? 60 days plus. 60. 60, please. Okay. 4 weeks.
41.
May it please your lordship. My lord, 15 days of delay, the IA has been.
15.
Yes, my lord.
Yes, madam, you are appearing here.
Yes, madam. Pay for less or less for.
Any objection in condemnation of delay?
No, madam.
No objection. Heard Mr. Rathil, learned counsel for the applicant, and Ms. Gayon for the respondent, opposite party. This interlocutory application is prepared by the applicant for condonation of delay of 15 days in preferring connected MFA against the judgment and order dated 26/8/2025 passed by the learned Railway Claims Tribunal Gauhati bench in original application number OA Roman 3/GHY/150/2013, which will get old. Mr. Rathil, learned counsel for the applicant submits that. What is the ground?
My lord, the applicant is a senior citizen and he was ill, because of which there was a delay.
Because of?
He was ill. He is a senior citizen, my lord, because of which he was ill, my lord.
Ailment.
He was not well, my lord. He was sick, because of which, my lord.
Where is the medical document?
My lord, I have not annexed the medical document, my lord.
Not annexed. Is any concession is granted to senior citizen?
My lord, he is outstation also, my lord.
The learned counsel for the applicant submits that the applicant herein is a senior citizen and he was not well, for which the appeal could not be preferred in time, and that the ground is not intentional and rather it is circumstantial, and under such circumstances he has contended to allow this application. Ms. Gayon, learned counsel for the opposite party, submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations so put forwarded in paragraph number 3. Paragraph number 3 and 4 of the application, this court is of the view that the delay is sufficiently explained and as such the same stands conduct. In view of the order passed in this IA, now the registry will register the appeal and list the same before the court as soon as practicable.
I'm grateful, my lord. Much obliged.
42.
May I please your lordship? Lordship, kindly adjourn the matter for the day.
Why?
My senior is not well. He's sick.
Okay. Miss, your name please?
D. Devi, on behalf of DCC Fukon.
D. Devi, learned counsel appearing on behalf of Mr. D.C. Fukon submits that conducting counsel Mr. D.C. Fukon is not well and as such she tries for listing the matter after
2 weeks time.
After 2 weeks. Mr. Sharma, learned counsel for the respondent opposite party submits that he has no objection. Accordingly, it is provided that SSL is the matter after 2 weeks. Any objection?
No.
When caveat is there, caveat would be hard, caveat stands and research.
Item 43.
May it pleases your lordship, the notices have just gone on 6/8/26, lordship, so we have to await service report. Office note 560.
Art Ms. Mazumdar, learned counsel for the applicant. Office note dated 8/6/2026 indicates that
No, office note 8/6/26. Notices have gone.
indicates that step was taken only on 5/6/2025 and the notices were issued on 6/6/2026. Accordingly, it is provided that the SSL lays the matter after 4 weeks awaiting service report upon the respondent's opposite party.
Highly obliged, Lordship.
44.
Lordship, in this case, as per office note dated Lordship 6/6. My learned plan is dated
One.
in respect of respondent 2, Lordship, service report may be awaited, Lordship. And we had sent steps through both ways, but registered AD returned that no such person, but usual process is yet to be received in respect of respondent number 2.
Heard, Mr. Soikia, learned counsel for the applicant. Miss, your name, please. Learned counsel for the respondent number 1. Office note dated 6/6/2026 indicates that answer notice in respect of respondent number 2 returned with a report that no such person returned to the sender. However, the said office note also indicates that step taken upon the respondent number 2 by usual process has not yet been received back. Accordingly, it is provided that SSL lays the matter after 2 weeks awaiting service report upon respondent number 2.
Item 45.
May it please your Lordship, I'm sorry to say that we have taken steps only yesterday, Lordship.
Yesterday.
Yes, Lordship.
Okay. Heard, Miss Mazumdar, learned counsel for the applicant. Ms. Mazumdar submits that only yesterday step has been taken upon the respondent opposite party. Accordingly, it is provided that SSL lays the matter after 4 weeks awaiting service report upon the respondent opposite party.
Highly obliged, Lordship.
Item 46.
May I please, Lordship? 51 days delay, Lordship.
50?
51 days.
Yes, you are for respondent number?
Lordship, on behalf of the respondent, Lordship, we have no objection.
No
Only
objection.
16 days it will be allowed.
16 days.
And matter may be fixed for it. Because the Lordship, since 1961,
Yes, yes.
their land were done under acquisition, Lordship. 37 bighas of land, Lordship, where the Dhamaji district court, Dhamaji judicial court over the land, Lordship. But till that, no compensation was received by the defendants, Lordship. Hence, Lordship, this matter may be fit for admission, and we have no objection in 16 days, Lordship.
Heard, Mr. T. Gogoi, learned junior government advocate for the applicant. Mr. Sarkar for the respondent.
Lordship.
Opposite part. This interlocutory application is preferred. Caveat is there. Caveat would be heard, caveat is decides. This interlocutory application under section 5 is preferred by the applicant for condonation of delay of 51 days in preferring appeal under section 54 of the Land Acquisition Act against the judgment and order dated 11/11/2025 passed by the learned district in section by the learned district judge Dhemaji in LA is case number 16 of 2019. Mr. Gogoi, what is the ground?
Lordship, they have, we have already prepared the LA appeal draft, and we have drafted the LA appeal, Lordship, but again, since transfer the district commissioner, a new commissioner called our drafted LA appeal, Lordship. Then we have returned the draft letter.
Okay.
Draft LA appeal to the Dhemaji district.
Mr. Gogoi, learned counsel for the applicant submits that the judgment was delivered by the learned district judge Dhemaji on 11/11/2025, and that the district commissioner who was holding the office at the relevant point of time was transferred, and thereafter new commissioner assumed search and in the process, the appeal could not be filed in time, and the same is not intentional, rather it is circumstantial, and also there is merit in the appeal, and therefore he has contended to condone the delay and to admit the appeal. Mr. Sarkar submits that he has no objection in the event of condoning delay of 51 days in filing the connected appeal. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations so put forwarded for the delay of 51 days in filing the connected appeal, this court is of the view that the delay is sufficiently explained and accordingly the same instance condoned. In view of the order passed in the IA, now the registry will proceed to register the appeal and to list the same before the court as soon as practicable. In terms of evidence, IA stands disclosure.
Number 50.
Delay আছে নাকি এটা?
ডিলে মানে রিভিউ পিটিশন ফাইল করছে, রিভিউ পিটিশন ফাইল করেছে to discuss any বেলেগ ডিলে নাই।
Delay আছে?
This I is for
Condemnation of delay, you are like, since review petition was filed, so during that period, delay was caused, your lordship.
I am making for the response number 1. I can.
this I is for condonation of delay.
I can file objection.
File objection. You have filed or you will be filing?
I will be allowed to file objection.
You need some time. Okay. Heard Ms. Chaudhary, learned counsel for the applicant, and Mr. Bhatt, learned counsel for the respondent, opposite party number? Respondent number 1. How many respondents are here?
There are, your lordship, there are three opposite parties are there.
Mr. Bhatt submits that he may be granted some time to file objection. Office note dated 9/6/2026 indicates that unserved notice issued to the respondent number 2 received with a remark insufficient address returned to the sender. Accordingly, it is provided that learned counsel for the applicant shall obtain necessary instruction and take fresh step upon respondent number 2 by speed post and also by usual process within a week from today. The said office note also indicates that as per postal journal, notice upon respondent number 3 was delivered on 17/4/2026. But the respondent number 3 remain unrepresented today. List the matter after 4 weeks awaiting service record upon respondent number 2.
Item, let me show. Item 1, order with.
Lordship, as per the last order, Lordship.
Okay, that's fine.
Lordship, the three instructions I have received, your lordship, the other instructions, but in a different, your lordship. For its submissions of the proposal, your lordship. For its submissions of the proposal, your lordship.
Yes.
Mr. Das, only yesterday this joining letter has been forwarded.
No, these three documents I have obtained from the inspector office yesterday, Lordship. These two documents, Lordship, she joined in the years on 16 September 2024, first joining letter. Then release order is also, but in the 9/6/2025 order, it has been stated that, Lordship, the inspector of school was not in the headquarter, Lordship. That is why the date of Lordship joining was allowed on 19 September. But I have joined on 16, Lordship.
And that also been reflected in our instructions also, Your Lordship.
Pardon?
Which learned senior fan has said about the in presence of the IS. That has been reflected even in our instructions, Your Lordship.
This is of 9/6/2025 also. The last
You are representing the director.
Yes, Your Lordship, I'm representing the director.
Whether the commissioner is a party here?
Lordship, it's part.
Who is appearing for the commissioner?
It's my learned friend will appear Department of School Education. Also.
I'm appearing, Your Lordship. I'm appearing.
Or
Secretary.
Commissioner.
It's only the secretary is only there.
for commissioner and secretary, you are appearing.
Yes, Your Lordship, I'm appearing. No, finance, I'm not appearing, Your Lordship.
Finance is not a party here.
Finance is a party, Lordship.
Respondent number 3, Your Lordship.
Right. On the last occasion,
Okay,
my
finance
learned-
department, okay. Now, before whom the matter is pending?
It is pending before the IS, Your Lordship.
IS?
Yes, Your Lordship. So we need to receive some documents, Your Lordship.
No, the proposal has already been sent to the government.
Yes, Your Lordship. So it is pending before the finance, Your Lordship.
Finance?
Yes, Your Lordship. So we did.
On what basis you are submitting?
Completed.
No, on what basis you are submitting it is pending before the finance department?
Because we have already resubmitted the proposal, Your Lordship, again.
Where is the document to show that you have forwarded it to the finance department?
Said I have forwarded Your Lordship in two competence, Your Lordship, I think.
No, there is no indication in this letter that the file was forwarded to the finance department. Hmm? Heard Mr. Das, learned counsel for the whether the finance department, standing counsel of the finance department is available. Okay.
On the last occasion, Mr. Solia appeared also.
After some time later.
No, sir.
Made visible. This is an appeal against an order passed on 31st of October 2025 in a money suit. Lordship, in the suit, there are altogether 49 plaintiffs joined together. Alleging that the defendant number 1 and 2, who are the appellants herein, they have borrowed money from them on different occasions by executing deeds in some occasion and somewhere verbally. But as they have not repaid, they have filed a money suit, a common suit matter. Operative portion of the judgment is at page 58.
Heard Mr. Sharma, learned counsel for the appellant. This appeal under order 41 rule 1 in the Code of Civil Procedure is preferred by the appellant against the judgment dated 31st of October 2025 passed by the learned Civil Judge Senior Division Lakhimpur in money suit number 2 of 2021. Where is the decree?
Decree is not there, my lord. At the last page, yes, it is there, my lord.
Pardon?
My lord, at page 62, my lord. At 66 is the page 66 is the operative portion.
This decree is updated same day.
Same day, my lord, 31st of October.
But you have not challenged the decree.
That correction I will do, my lord. Correction I will do, my lord. I've challenged the judgment, my lord. I'll mention
UP order 41 rule 1.
Yes, my lord. Yes, my lord. That correction I'll do, my lord. I'll mention the judgment.
Appeal will lie only against the decree.
I'll correct the memo of appeal, my lord. I'll file an
Heard Mr. Sharma, learned counsel for the appellant. Mr. Sharma submits that he may be granted some time to file corrected. Amended memo of appeal is paired allowed, list the matter after 1 week.
Oh, sorry, my lord. No, mistake is.
Mr. Soliha. As per submission of Ms. Terangti, this matter is now pending with the finance department.
Lordship.
Can you obtain up-to-date instruction?
Lordship, if any details can be furnished, that there is a number, Lordship, file number or letter number through which.
No, nothing has been furnished by her. It is her verbal submission that the matter is now pending before the finance department.
Lordship. Like that, if it's Lordship, there I can always ask for an update, Lordship. A short date may be given, Lordship.
Short date.
Yes, Lordship. Okay. If it has been actually forwarded, Lordship, we can find out, Lordship.
Heard, Mr. S. Thus, learned counsel for the petitioner. Ms. Terangti for the respondent number 1 and 2, and Mr. Soliha for respondent number 3. Ms. Terangti has produced one letter before the court today. Addressed to the Commissioner and Secretary to the Dr. Basam Education Department by the Director Secondary Education. Dated 9/6/2026, and on the basis of the same, she submits that the pay protection proposal along with release order and required documents is resubmitted for according necessary approval from the government in respect of Srimati Gitasri Das, Principal of Sorno Lakshmi Higher Secondary School, District Kasar. And that the matter is now pending with the finance department. In that view of the matter, Mr. Soliha, learned extending counsel for the respondent number 3, is directed to obtain up-to-date instruction in respect of the said proposal and to apprise this court on.
Lordship, a short date may be given. On that day, I'll confirm whether we have received the proposal or not. Next week's any date, Lordship.
Friday.
Lordship, yes.
Family item 30.
May I please, Your Lordship. I raise, my lord, for condonation of delay of 210 days, my lord, in preparing first appeal, my lord. Ground, my lord, I have stated that para 4, 5, 6, 7, and 8, my lord. What happened, my lord? Though, my lord, I have engaged one advocate, my lord, to conduct the, my lord, during trial, my lord, but he has not, my lord, contested the case, my lord, and ultimately the suit was decreed ex parte, my lord. On, my lord, 24/5/2023, my lord, the bailiff of the court, while executing the, my lord, decree, visited the, my lord, my residence. At that time, I was not present, my lord. And I have came back on, my lord, 31/5/2023, and immediately, my lord, I have inquired and I have applied for certified copy, my lord, and that was obtained on 14/6/2023. And immediately thereafter, my lord, I have filed this, my lord, first appeal, and there was, my lord, delay of 210 days in preparing the appeal, my lord. The objections, my lord, the respondent filed, my lord, they have basically stated that I have not lodged any complaint against the, my lord, earlier advocate, my lord. So, my lord, it is settled position of law that the litigant, my lord, should not be suffered due to, my lord, mistake, negligence, or inactions on the part of the, my lord, his or her counsel, my lord. And, my lord, I have no any intentional delay, my lord. When, my lord, I came to know on 31/5/2023, my lord, immediately, my lord, I have applied for certified copy, my lord. I have got it on 14/6/23, my lord, and I have filed this my lord, appeal on 26/6/2023, my lord. So, my lord, I was, my lord, prevented by sufficient cause, my lord, from preferring appeal, my lord.
Yes.
May I just matter? If ballot comes to paragraph number 4 of the petition ballot, their contention is that it appeared that appeared on 21/12/2021 by
Para 4 of your
No, my
of their petition.
of their petition. Okay.
Page 5. So on 21/12/2021, ballot they had appeared before the Learned Trial Court by engaging an advocate. Named Spencer and authorized and instructed him to take necessary steps to file written statement on behalf of the applicant appellant. But from 21/12/2021, the judgment was passed on 30/8/2022, and the bailiff went to the decretal land or property on 31/5/2023. For 2 years, my lord, if I assume that it is correct that they had engaged an advocate and they appeared through him on 21/12/2021, for 2 years, the advocates also did not take step, and neither did they take step, my lord. If, my lord, for the conduct of the advocate, if I agree also, my lord, that the party should not suffer, but what was the party doing itself, my lord? She did not come before the advocate, she did not file written statement, and she's not a rustic lady, my lord, she is a builder. I have given my plot of land measuring 1 quota 6 acres for construction, my lord, and she has constructed and she has not given my share of property. She is not a layman, my lord. She knows that for filing of a written statement, her signature is required. It has to be filed by way of an affidavit. She has to file evidence also, my lord. Cross-examination has to be done. So for 2 years, she has absolutely no idea that, my lord, the case was going on and her lawyer was conducting the case, and she has not paid a single penny to the lawyer. And the lawyer was conducting the case, and she was of the application, my lord. Is it believable, my lord, that my lord party, she will not contact the lawyer for 2 years, and she of the belief that, my lord, my lawyer is taking good care of the case and he is taking steps regularly, although I am not in contact with the lawyer, my lord. So my reciprocal submission is that, my lord, these are all afterthoughts, my lord, manufactured and fabricated statements, my lord, just to make out a case for condoning the delay. Once, my lord, the delay is done, the first appeal will be admitted, my lord, thereby it will take years to come. And my share will go for a, my lord, cakewalk, my lord. So, my lord, in this regard, I have got 2 judgments, recent judgment of the Supreme Court, my lord. Specifically on the point, my lord, about the naming of advocates, my lord. The first judgment, my lord, to take up Rajneesh Kumar versus Prakash.
This is first appeal or second appeal?
First appeal.
But in your written objection, you have mentioned it as second appeal.
My lord, typography. But the first judgment, my lord, may take up Rajneesh Kumar versus Prakash. That was rendered on 21/11/2024. My lord, will take up paragraph number 10, 11, 12, and 13. Specifically on the same point. Para 10, may I read, my lord? It appears that the entire blame has been thrown on the head of the advocate who was appearing for the petitioners in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Even if we assume for a moment that a concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant on his own rights and is expected to be equally vigilant about the judicial proceedings pending in the court initiated at his instance. The litigant therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. 11. In the aforesaid context, we may refer to a decision of this court in the case of 1983 to SP 185, para 8. The advocate is the agent of the party. His acts and statements made within the limits of the authority given to him are the acts and statements of the principal, that is the party who engages him. It is true that in certain situations, the court may, in the interest of justice, set aside a dismissal order or an ex parte decree notwithstanding the negligence and or misdemeanor of the advocate when it finds that the client was an innocent litigant. But there is no such absolute rule that a party can disown its advocate at any time and seek relief. No such absolute immunity can be recognized. Such an absolute rule would make the working of the system extremely difficult. The observations made in so and so must not be understood as an absolute proposition, as we have mentioned here above. This was an ongoing suit posted for final hearing after a lapse of 7 years of his institution. It was not a 2nd April file, but a villager residing away from the city where the court is located. The defendant is also not a rustic, ignorant villager, but a private limited company with its head office at Calcutta itself and managed by educated businessmen who knew where their interest lied. It is evident that when the applications were not disposed of before taking up the suit for final hearing, they fell sick and refused to appear before the court. Maybe it was part of the delaying tactics as alleged by the plaintiff, maybe not. But one thing is clear, they chose not to cooperate with the court. Having adopted such a stand towards the court, the defendant has no right to ask for his indulgence, putting the entire blame upon the advocate and trying to make it out as if they were totally unaware of the nature or significance of the proceedings is a theory which cannot be accepted and ought not to be have been accepted. Para 12, as regards the law of limitation, we refer to section 1702 SCC. The necessity for enacting periods of limitation is to ensure that actions are commenced within a particular period. Firstly, to assure the availability of the evidence documented as well as the order to enable the defendant to contest against him. And secondly, to give effect to the principles that law does not assist a person who is inactive and slips over his right by allowing them, when challenged or disputed, to remain dormant without asserting them in the court of law. The principle which forms the basis of this rule is expressed in the next thing. So and so. Therefore, the object of the statute of limitation is to compel a person to exercise his right of action within a reasonable time, so as to discourage and suppress stale, fake, or fraudulent claims. Whereas, in view of the aforesaid, we find no error not to speak of any error of law in the appeal judgment of the High Court warranting interference with also. Similar judgment, my lord, Niti Mahadev Dwala versus Bhaskar Mahadev Mukhe.
Where the delay is condoned.
Delay, my lord, in preferring a special leave petition, my lord. Otherwise, the main delay that must not condone. The High Court has refused to condone that. Here, my lord, next judgment, paragraph number 6 and 8, my lord. We have noticed over a period of time, saying language is my lord, the growing tendency on the part of the litigants in throwing the entire blame on the head of the advocate. Not only this, we have found across cases where the concerned advocate has filed etiquette in favor says he was unable to attend the proceedings due to some personal reasons, difficulties thereby facilitating the litigant to get the delay control. 7. Even if you assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate delay, as the litigant owes the duty to be vigilant of his own rights and is expected to be equally vigilant about the judicial proceedings pending in the court initiated at this time. The litigant therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at the time and seek relief, my lord. So similar is the case, my lord. Only ground that has been shown in the present case is that the advocate did not take steps, whereas they were themselves sleeping over their own rights. So my responsible submission is that, but considering the grounds, so that is not itself would be an ipso facto sufficient.
No, Mr. Iqbal, you see, this is first appeal.
No.
Statutory appeal.
But without going to the merit of the appeal, if it's just sufficient, whether they are able to show any sufficient cause, my lord.
Pardon?
But without going to the merit of the case, my lord, if I assume whether they have been able to show any sufficient cause to condone the delay, my lord. My response submission is that, my lord,
No, they have offered one explanation, but whether it is sufficient or not, that will be the subject matter to be decided by the court.
that matter decided. My response submission is that, but that will not come within the scope and ambit of the sufficient cause to condone the delay, my lord. Because only blame is put because of the advocate, they did not know ever. So what were they doing, my lord? At least they could have visited the chamber of advocate's chamber, my lord. In fact, my lord, if my lord says that on 1/6/2024, they went to the advocate chamber after coming to know about the ex parte judgment, and they took the brief. And did not confirm the advocate, did not ask him why you did not take steps. And no explanation is there in the regard, my lord. straight away they have filed this appeal.
Okay, we'll pass the order. All right.
Pending item 33.
Made please, Your Lordship. Look, the limitation occurred in land acquisition case. My lord. Land acquisition appeal I have filed, my lord, because the compensation was less. Now, my lord, the respondent side filed objection against this limitation petition. My lord, my humble submission before your lordship. I have stated my petition, my lord. There is delay, my lord. Delay is considerable, 2 years, 1 day. My lord, the matter involved is compensation, my lord. Because, my lord, my land has been taken by the railway, my lord, for construction of railway bridge, railway line from up to Jugirgopa, my lord. So, my lord, my humble submission before your lordship, the delay I tried to explain that your lordship will look into and whether it is sufficient cause of delay. So, my lord, overall, my lord, my submission before your lordship, when money is involved, my lord. Money is involved. I am an agriculturist, my lord. My land has been taken away for the final taken away the land, my lord, and money is involved, my lord. So, my lord, on the ground of this, that when property is involved, immovable property is involved, my lord.
Mr. Sheikh, you have already received compensation.
My lord.
You have received the compensation. You have received the compensation.
I have received the compensation only.
But according to you, you are entitled more compensation.
My lord, yes, compensation is less. I am claiming more compensation. Because, my lord, and
so what is the explanation?
Explanation is this, my lord. I was in the impression that after receiving the compensation only I can file the appeal. That was my impression. So, my lord, after receiving that compensation amount, my lord, I approached the advocate of Gauhati High Court, my lord. And when I came to Gauhati High Court, my lord, then the advocate said that you see one document is necessary. What you have exhibited in the record, that is the deed. The deed is to compare the land value. So that deed is necessary and you bring that sale deed. Then they went there to bring the sale deed, and in the process, my lord, there is delay. Two steps of delay. First one is my impression that after receiving the amount, I can file appeal. That is my impression only. And secondly, my lord, when the appellant came to Gauhati, my lord, advocate advised them that that document is necessary, otherwise appeal cannot be filed. That is why, my lord, 2 steps to delay. And they failed file objection, my lord, that it cannot be condoned. It's a general objection, my lord, general objection. It is not that. So, my lord, my land is taken away. Your lordship will consider that that is the last resort of my income, and that has been taken away. And now I am claiming some increase of compensation. That is the case, my lord. And when money, consideration of money and immovable property involved, my lord, there is decisions of your lordship and as well as the Supreme Court that should
Mr.
be reliably
Gogoi,
taken.
you have filed objection here. Or who? You?
That's it. For respondent number 2.
What is your objection?
There is no explanation of delay, Lordship, at all. It is a 731 days delay.
2 years.
And they have not
2 years.
explained at all.
No, you come to paragraph number 3 of the application. There, the applicant has mentioned the ground.
There is not sufficient ground, Lordship. They have stated that they were waiting to receive the final amount. Only after receipt of the final amount, they challenge
No, is it not a ground?
It is not a ground logic.
Hmm?
It cannot be a sufficient ground logic. Because there is no bar that unless the final amount is received, they cannot challenge the appeal order. It has to be sufficient also. Delay consider 731 days delay.
Okay, we'll pass the order. My lord.
There is a process order regarding prolongation of legal option.
Okay, we'll see.
My lord, it is similar, my lord, that LA. Similar is the explanation, my lord, of delay. Oblige, your lordship.
Items for admission, item 3.
Yes, I am filing affidavit in opposition today. So a date may be fixed for it.
Okay. It should be after vacation only.
Your lordship, there is an injunction order.
Maybe. That order will continue. Part Mr.
C. Gogoi.
C. Gogoi, learned counsel for the appellant, and Mr. Parvez, learned counsel for the respondent. Mr. Parvez submits that he has filed the affidavit today, but it appears that the same has not been placed on record. Accordingly, it is provided that recessor leaves the matter on COVID.
19 June.
No.
After vacation.
After vacation.
15 July.
15th of July.
Your lordship, interim order.
Place the matter and shall take the affidavit filed by the learned counsel for the respondent with the record. Interim order, if any, pass earlier shall continue.
Much obliged.
Item 4.
Please, Your Lordship. Appeal under section 96 of CPC, challenging the judgment and decree dated 4/11/2023, whereby Lordship the appellant's APDCL was directed to pay a compensation of rupees 20,77,500 to the defendant number 1 to 5. The relevant portion of the decree, Your Lordship will find at page 71 and the direction. The appeal is yet to be admitted, Lordship.
So this amount of compensation has to be paid by you.
Lordship.
Yes, any objection?
Your lordship, appeal admitted, but stay after 50% of the.
Part. Mr. Bora, learned counsel for the appellant. And Miss, your name, please?
B. Sarkar.
B. Sarkar, learned counsel for the respondent number?
Tier 25.
Respondent number 125.
One is expired, 225.
225. Mr. Bhattacharya for respondent number 6 and 8. Respondent number 6 and 8. This appeal under section 96.
Investigate the incident.
Mr. Gogoi learned, no, Mr. Bhattacharya, sorry. Mr. Bora, learned counsel for the appellant. No, this appeal under section 96 of the Code of Civil Procedure is directed against the judgment and decree dated 4/11/2023 passed by the learned civil judge senior division Hailakandi in Manuscript number 10 of 2019. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division Hailakandi within bracket first appellate court has directed the appellant herein to pay a sum of rupees 20,77,500 within a period of 3 months from the date of decree, with interest at the rate of 6% per annum. From the date of decree. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 4/11/2023. Admit, issue notice to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 2, 3, 4, 5, 6, and 8. Step upon respondent number 7 be taken by speed post and also by usual process within a week from today. The learned counsel for the respondent number 2, 3, 4, 5 submits that respondent number 1 Mosammed Sahida Begum Loskar suffered demise when
1 more.
11/7/15.
11/7/2015.
Expired.
2015.
11/7/2015 while working under the defendant number 5. Expired.
2015.
No, Lordship, that is the person who died against whom the claim was.
No, this is respondent number 1.
Sahida Begum Loskar.
Sahida Begum Loskar.
Zia is
on behalf of
No, Zia is Morley.
no.
No, she is there. Lordship.
Your Lordship.
Okay. You are not appearing for her.
Yes, Your Lordship, I am repairing one itself and 2 to 5 for minor.
1, 2, 3, 4, and 5, Lordship.
Okay. 1, 2, 3, 4.
2 to 5 are minor. Is there in the petition, my lord, in the.
No, they are represented by 1. She is the mother.
They are written by the mother. It is stated in the petition. That is important, my lord. 2 to 5 are minor. That is very important. They are represented by their mother, my lord.
The learned counsel for the respondent number 1, however, submits that respondent number 2, 3, 4, and 5 are minor and are being represented by the respondent number 1. Step upon respondent number 7 be taken by speed post and also by legal process within a week from today. Recess will call for the record from the learned court below. Place the matter after 4 weeks. IA 50% deposit the amount before the registry of this court. And on such a deposit being made before the registry of this court, the respondent opposite party number 1 to 5 will be at liberty to withdraw the same.
So may I pray that only the 50% of the principal amount, but not of the interest.
Entire amount.
Lordship, in respect of respondent number 7 and 8, they are the headmaster, come member secretary, and deputy commissioner Hailakandi. So the government advocate can represent them. Formal notice may not be
He may
required.
not represent the headmaster.
Lordship.
Others are represented by him.
Lordship.
8, 6, and 8 already, my lord. That I stated already.
Lordship, we'll take steps.
That will be the education department, I think.
We'll take steps. Lordship.
They will have to find out while starting notice.
Next item.
Obliged.
6 and 8 I'm repeating. And number 5.
May I please, Your Lordship? The matrimonial appeal, Your Lordship, wherein the divorce was granted in favor of the respondent husband and the claim of the wife of the who is the appellant here for permanent alimony and
is so and so. The learned trial court has allowed the petition filed by the respondent herein under section 13(1), which will make it Roman 1 small a of the Hindu Marriage Act 1955, read with section 27 of the Special Marriage Act 1954, and thereby dissolve the marriage between the parties. Whereas the memo of appeal and the grounds mentioned therein, and also whereas the impugn judgment and decree dated so and so. Admit issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned court below. Less the matter after 4 weeks. Part Mr. So learned counsel for the applicant. This application under order 41 rule 5 CPC read with section 151. CPC is preferred by the applicant for stay the execution of the impugn judgment and decree dated 27/4/2026 passed by the learned district judge Morigao entitled suit divorce number 20 of 2020. There's the application and the documents present record and also there's the impugn judgment and decree dated 27/4/2026. Let notice be issued to the respondent, opposite party, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. And considering the submission of Mr. Ahmed, learned counsel for the applicant, operation of the impugn judgment and decree dated so and so stands straight till returnable date. Since this order is being passed in absence of the other party, the other party will be a liberty to file any application for vacation of the same, if so advised, list after 4 weeks.
Lordship, the 10,000 amount may be continued.
No, that cannot be considered at this instance. Let the other side appear and you file appropriate application, we will consider it.
All right.
Number 6.
Eight pieces, madam. Well, this is a regular first appeal under section 96 of the CPC law. So my respectful submission is that the appeal may be admitted, notices may be issued.
Part Mr. Iqbal, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure is directed against the judgment and decree dated 10/3/2026 passed by the learned. Civil Judge Senior Division number 2, Kamrup M. Gauhati, which will make it herein after the appellate court. Trial court. In title suit number 125 of 2011, whereby the learned trial court has dismissed the suit of the appellant struck plaintiff. Whereas the memo of appeal and the grounds mentioned therein, and also whereas the impugn judgment and decree dated 10/3/2023 passed by the learned trial court. Admit issue notice to the respondent, returnable in 4 weeks. Respondents. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Rest shall call for the record from the learned trial court. List after 4 weeks.
Obliged.
7 and 8.
It is a lordship. Yes, the action has been filed mainly on the ground that insurers have no liability. But before that, lordship, I'll have to take your lordship to ground number 2 of my memo of appeal. This is a case
So there is a subtle principle of law that insurers can be held liable only when the insured is held liable. Now this case has proceeded, Lordship, ignoring the insured altogether, owner of the vehicle altogether, Lordship. He was implicated as a party, opposite party number 1 in the claim petition. But thereafter, if your Lordship goes to the judgment, and it's a total confusion. He has been total, his name is nowhere mentioned in the judgment. There is a hirer of the vehicle, Gammon India, which is the biggest construction company in the country. So, Gammon India has been objecting also, they are not the registered owner. And in spite of that, Lordship, there is no mention, even we do not know whether any notice was sent to OP1, because there is total absence of the OP1, who was the Soti Mohan Saha, owner of the vehicle. Gammon India has been made OP1. It's a question, Lordship, the subtle principle law is once the insured is held liable, because then only the insurer can be held liable. Here the insured is missing, Lordship. And it has very serious consequences. If the insured is not there, who will be in that case if the suppose insurer is not liable, Lordship? Who will pay compensation to the deceased? It's obviously has to be the one who is and this deceased was not the employee of the owner of the vehicle. They were the employees of the hirer Gammon India. Admittedly, even evidence, they said they were employed by Gammon India.
No, now liability is trusted upon the appellant.
Yes, Lordship. Without making the insured liable. Insured is nowhere in the picture, Lordship. Lordship, insured is nowhere in the picture. Lordship, going to the judgment, Lordship, it will be very clear. I'll read out part or 3 of the judgment. Then Lordship will, the position will become clear, Lordship. Para number 4 of the judgment, Lordship. Somehow there is a serious confusion, insured has been ignored altogether. And we are saying, the Gammon is saying that they are not responsible, they are not a registered owner. We are saying, we have given evidence that they were the employees of Gammon, therefore not the employees of the insured. It's a very serious disputed questions of liabilities there. Lordship, para number 4. After filing of the claim petition, Lordship, para number 4 to judgment, notices were issued to the opposite parties. In response to the above, the opposite party numbers 1 and 3 entered appearance and filed written statements in order to contest that. None appear on behalf of OP number 2. Now, Lordship, against 4 parties, it mentions of talks of 3 parties only, because it is presumed that Gammon India is the owner. I'll go to the other paras. It's very clear. Insured has been, somehow there's a big confusion. Insured has been altogether driven out of the picture, Lordship. Lordship, I'll read the next para. Opposite party number 1, by filing written statement, has stated the claim petition is not maintainable. There is no cause of action for the case. The claim petition is barred by limitation. The claim petition is bad for non-gender and misgender of necessary parties. It has denied all the averments of the claim petition as the claimant to strict proof of it. The OP number has also denied the information given in para numbers 11, 12, 13 of the claim, stated that OP number 1 is not the registered owner of the vehicle involved in the accident. It has also no knowledge about the involvement of offending tractor in the accident. OP number further pleaded it has not got any liability to pay compensation, and therefore it is paid for striking out from the proceeding. Lordship, then I'll take your Lordship again to the para number 12, Lordship. Clearly, they were employees of not the owner of the vehicle, employees of another entity, Gammon India. In the cross-examination, para number 12, Lordship. In the cross-examination, PW1 stated that she did not see the accident. As per claim petition, the income of her son was rupees 5,000. But as per affidavit evidence, his income is 9,000, but no document is submitted to that effect. She did not submit the postmortem report of her son. Her son was working for Gammon India Limited company for last 2 years. This changes the entire picture. They were not, if at all someone is liable, it's Gammon India who is liable for its employees. And they were never the employees of the owner of the vehicle. There is also settled position the insured can be there, that the insurers cannot be held liable for employees of hirer of the hirer.
only for the employees be insured, the insurer can be held liable. Very clear, settled position or the judgment should it affect Lordship. I'm having those judgments with me.
No. Today we are not deciding the appeal.
Lordship, yes, Lordship. This my humble position was that this may be fixed for admission hearing. That was the whole point of saying this, Lordship. Maybe next week or any time without looking at it.
No, admission hearing means let us admit the appeal.
And this
Let the record come. Without the record, can we dispose of the matter?
Record, yes, Lordship. No, that matter may be admitted, Lordship. Records may be called for, but Lordship, I will not be able to deposit. Difficulty in depositing any amount, Lordship, where I have denied the liability altogether.
Unequivocally, Your Lordship, the bedrock of this act, MP Act, is always there that it is for the beneficiary. It's a beneficiary act. So this claim, the victim should be deprived of any cost. I have no objection regarding what has been said, but thing is that there are different. Here's this our I'm acting for the respondent. Respondent is no way. He's a third party here. It's neither party in any of the contracts. So my humble submission is that why should we suffer? But it is a case of intrinsic dispute because both the government in India is a very big public limited company and is also public limited company. So in an intrinsic dispute, why my livelihood, why my life should suffer? That is the main point to be decided at this point. So intrinsic dispute, I shouldn't be suffer because I have no wrong with me. I was the third party and has been decided. So I have nothing to say who is that because 2, 3, contracts are there. In the higher this insurance companies and the insurance, but unequivocally there the accident has taken place. A vehicle has involved. Appellant has insured. That I don't think at this point of time it may be half of the amount may be given because the evidence is going to vote for if the amount is given. Because the amount is not given. Look at this case has been taken place 30 years back. The case is a long ordeal of sufferings. It is a mother. And this is the bedrock of the thing is that this is beneficial. Is why this claimant, poor claimant should suffer for his injuries.
No.
Has there been no accident taken place? Does the vehicle is
if
involved?
the insurance company has no liability, then why should they pay?
Company has no liability that will be decided at a later on. But if they have no liability, you will recover it from the other party. So there's an interest dispute, and there's a other party is also a very big company. This insurance company has last year out of the quarter say 100 crores of rupees there with profit. No hazard is going to fall if my livelihood of my client of my this poor mother has been saved. Then why should I suffer? Because what they are challenging, that is an adjudication of the trial court. It's not an executive order they are challenging, because where it has been proved. And otherwise, there is some mistake. Apart from that, if there is some mistake that we could have really, for whatever may be the reason, that would have been rectified as a review, but not that is different. But my thing is that I shouldn't suffer. This act is made for me. Unlike
No. You first tell me if the insurance company has no liability, why should they pay?
We all due respect with the insurance company do have a liability, and for that liability, this judgment has been passed. And at the time of hearing, it will be said, I do not have whether they have a liability or not. But thing is that if they have no liability, then it will be rare. It is a Gammon India, that's another big company. So it is a case of two big companies.
So no. Who is the owner of the vehicle?
Owner of the vehicle is the respondent number 4. It is
Opposite party number 1.
And well, it is his name is reflected there. For
Respondent number 4.
One.
One.
Initial claim petition. For the claim petition, tribunal, if the lower court record be called for, it will become very evident there. But for some typographical error, why should this claimant suffer? Because finally, it is a procreation of a judicial adjudication.
No. Who is the owner of the
Owner
vehicle?
of the vehicle has been implemented as OP number 1, Soti Mohan Saha, son of Sasi Mohan Saha, Beltrala Nalmati, etc.
And he has been amended, but it hasn't been reflected.
So he is not a made party. So
Yes.
in original claim petition, he was a party.
He was a party, but the judgment has, trial court has proceeded as if he was not there. Lordship, I have read out the notice.
Can there be any reason for depriving me of this?
Let me finish. I was asked this
Please
question.
sit down.
Gammon India has been referred to as OP number 1 all throughout. Gammon India. Despite her mother says he was an employee of the Gammon India. And Lordship, I have just even said that it's a very clear judgment of Supreme Court. Insurers can be held liable only when the insured is held liable. There is not a statement in the judgment that insured is liable. The Sotiman Saha is liable.
No,
we
but
cover the liability of
that
Sotiman
owner
Saha.
of the vehicle was a party before the tribunal.
Tribunal.
He was a party.
He was made a party.
Okay.
But we do not know whether he has been served with notice and why he is not be mentioned even once. Instead of OP.
And the vehicle was insured with you.
With us.
Then?
No, definitely. But the owner has to be first held liable, because I said that there's again under judgment I have given Lordship that insurers are liable only for the employees to the insured, not of the hirer. There's a very clear judgment I have given that judgment. Para number 2425 of this judgment. And Lordship, even if for all recovery purposes, the judgment of the three judges that is the owner who is held to be held liable. If suppose after 10 years, someone is to be held liable, is the owner of the vehicle, registered owner, and here is never the registered owner. This judgment of the Supreme Three Judge has made a very clear distinction: who is a registered owner and who is a hirer. A hirer can never be held liable. It's a registered owner who has to be held liable, even if after 10 years it is found. There have been subsequent sales, many sales, but still the original RC holder would be held liable. From all points of view, Lordship, because even if I am to recover from somebody, from whom shall I recover, Lordship? It has to be from the insured, the owner of the vehicle. Here, nothing has been said about him. He is totally forgotten in the judgment. Not a single word about him in the judgment.
So, at the relevant point of time, the vehicle was insured with you,
Yes, sir. Yes, no problem.
and the policy was valid at the relevant point of time.
Yes, yes, Lordship.
And one Soti Mohan Sinha, he
Yes,
is the registered owner of the vehicle,
Yes, Lordship.
and he was arraigned as a party in the claim petition.
Yes, Lordship.
So, what wrong with the judgment then?
Lordship, it does not discuss the liability of the insured first. It has to discuss the liability of the insured, then hold the insurer responsible.
Hmm.
Here, Lordship, insured is missing altogether in the judgment. How can any liability be attributed to him? Later on, he'll turn around and say, no, I was not held liable for anything.
You are not disputing that the policy was in force,
Yes, Lordship.
and the policy was valid at the relevant point of time. Then,
But then policy is subject to terms and conditions, exceptions in the policy. Policy is just by itself, there is a policy, there are lots of judgments to the effect. Just mere existence of a policy does not make the insurer liable. Like when the DL is not
No,
here,
maybe.
permit is not there. In this case,
the supposing the vehicle was hired by the Gammon India Limited,
yes, Lordship.
then who will pay the compensation?
Lordship,
The owner of the vehicle will be responsible.
Lordship, but then this owner of the vehicle will be responsible only for his employees, not the employees of the hirer, owner of goods. Lordship, I have begin personal judgment, Sanjeev Kumar Samrat. Lordship very clearly says that insurer is not liable for any other employees except the employees of the insured. In this case, they are admittedly employees of the owner of goods.
No. There is no such finding in the impugned judgment.
Admission of the mother.
Hmm?
Paragraph number 12 of the judgment, Lordship. That her son was working with Gabon India for the last 2 years, Lordship. So were they employees of the insured to make me liable? Gabon India uses that vehicle for carrying their goods from here and there.
Let us admit the appeal. We will call for the record. And we will finally hear the matter, but no stay. He can go and execute the award.
May call for the LCR, fix a date for fix a date for the next for receipt
Will not fix the date. The record has to come.
Yeah, record has to come.
Notice has
Receipt of
to-
records only.
The only thing is that once the court is called, then that adjudication proceeding become almost infectious and lower court.
No, that can be continued by opening one. Okay, we'll call for the scan copy of the record then.
Yes, sir.
Heard, Mr. Argusami, learned counsel for the appellate. Mr. Your name, please?
Argusami.
Argusami, learned counsel for the respondent. Respondent number?
1.
Respondent number 1.
Put the case in 6, it is
same.
1 and the other one, 1, 2, 3, 4.
In other case?
Yeah, other case.
This appeal under section 173 of the MB Act is directed against the judgment in award dated 17/5/2023 passed by the learned member, Motor Accident Claim Tribunal number 2, Kamrup M. Gauhati in MSC case number 32 of 2014 filed under section 166 of the Motor Vehicle Act. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated so and so. Admit issue notice to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Goswami entered appearance and received notice. However, extra copy of the memo of appeal be furnished to him during the course of the day. Step upon respondent number 2 and 3 be taken by speed post and also by usual process within a week from today. Rest is call for the scanned copy of the record from the learned tribunal. List the matter after 4 weeks, along with the IA number 1081 of 2026. List after 4 weeks.
Obliged, Lordship.
Same order in the other petition also.
Yes, sir, same. Obliged, Lordship.
Okay.
With respect to item 47, it was heard earlier, Lordship, on the last occasion, I prayed that the selection process that was undertaken may be brought to his logical end, Lordship, and since there was a panel prepared by the school selection committee, Lordship, and my name was included in that panel. It's at page 55, and that may be finalized, Lordship. That was my submission, Lordship.
Yes.
Now, Lordship, on the last occasion, I relied upon a paragraph from my rejoinder to assert my submission, Lordship. And my friend, he said that, Lordship, he didn't have that affidavit, so it was postponed on that ground.
Pardon?
It was postponed to this date, Lordship, due to that, Lordship.
Ah.
And now, Lordship, my submission remains the same, Lordship, since I have legitimate expectation of being appointed, Lordship. So that election process may be brought to its logical end, Lordship, by acting on the panel prepared by the. And with regard to the other matter, Lordship, Lordship, in this case, there was an advertisement of 18/6/2016 with regard to filling up of a post of principal in Abdul Hasib Higher Secondary School, Lordship. The petitioner also applied, and interview was held on 11/12/2016. Lordship, in the interview, Lordship, it's at page 14. My name is at serial number 1. I secured a total of 11 marks, Lordship. And the incumbent at serial number 2, Faiz Muhammad Borbhuya, he secured 13 marks. Now, the respondent number 5 in this case, Abdul Rob, he is at serial number 4. He secured 11.5 marks. Now, the dispute is with regard to the marks awarded against the leadership skill, Lordship. I secured 4.5 marks and Abdul Rob secured 3.5 marks against the leadership skill, Lordship. Now, this leadership skill is...
No, the total marks are awarded will be counted.
Yes, basing upon...
In all the components.
Yes, Lordship. There are 3 components basically, and against each component, 5 marks is there. Out of that 5, you will have to award marks. So that leadership skill, Lordship, against that I secured 4.5, and in Abdul Rob's case, he secured 3.5. Now, what happened, Lordship? He was appointed, Lordship, subsequently, and since that Faiz Muhammad Borbhuya was appointed as principal of another school, Lordship, Abdul Rob, respondent number 5, was appointed as principal of that Abdul Rob High School. Lordship, the appointment order, it's at page 15, Lordship.
Yes.
On recommendation of the State Selection Board, Assam, and in pursuance to the government approval accorded by letter number so-and-so dated 19/6/2017, and subject to reversion without notice and without assigning any reason of thereof. Abdul Rab MSc B.Ed subject teacher is hereby appointed as principal on regular basis and posted in Abdul Hasib Higher Secondary School. Lordship, this is the order. Subsequently, Lordship, at page 20, some complaints were received that there was action taken against that Lordship. Lordship, I am reading it. I am enclosing herewith a copy of letter number so and so dated 8/6/2017 received from the office of Honorable Chief Minister regarding selection of principal of Abdul Hasib HSS. As per the information provided to Sri Dayal Das under RTI, there is mismatch in the pass percentage. You are therefore requested to inquire into the matter through Srimati Mamata Hojai, Joint Director Secondary Education, until then appointment of Sri Abdul Rab as regular principal may be kept in abeyance. So his appointment was kept in abeyance and an inquiry was ordered, Lordship. This inquiry is at page 21. It starts at page 21. The relevant would be, Lordship, page 23. Lordship, herein at the bottom, there is a list, Lordship. In that list, the number, total number of students appeared, it's the third column, Lordship. In 2015, against the art stream, 97 students appeared from his school, Lordship. And in the science stream, Lordship, it was 23, Lordship. This was found to be wrong later, and I will show that later on, Lordship. It's 23 here. And in 2016, against the column arts, it's 83 students, Lordship. This was also wrong, Lordship. I will show that also, Lordship. And against the science stream,
That's all right, but have you challenged this inquiry report here? No.
This inquiry report is not under challenge.
Not challenge. Then?
Lordship, in the inquiry, it was found, Lordship, at the second table, Lordship, the result is there, Lordship. Against in 2015, against the science stream, there were 30 students, Lordship, not 23 as reflected in the earlier table, Lordship. So that was the anomaly found. And due to that, Lordship, the pass percentage changed from 56.5 to 43.33. Now that other thing that, Lordship, with regard to 2016 arts, 83 students appeared. That I will show later on, Lordship. I can show now also, but Lordship, that was not taken into account in the inquiry report. Although not taken, Lordship, there was a calculation made, Lordship, wherein it was found that against the leadership skill, 3% is to be allotted to Abdul Rab, Lordship. That calculation is here.
Now the marks are equal.
Now the marks are equal, Lordship, in terms of this inquiry. Lordship, what had happened during that the entire process, Lordship, he approached, the Abdul Rab approached this court and obtained a stay against that order of the government whereby his appointment was kept in abeyance, Lordship. This abeyance order, I just showed it to your Lordship. It's at page 20. This page 20 was kept in stayed, Lordship. At page 29, the order is there, Lordship.
Page 99.
Page 29, yes, Lordship.
99.
29. Lordship, the last paragraph, Lordship. In the interim, since the petitioner was recommended by the State Selection Board, the operation of the impugned order dated 28/6/2017 is stayed. In other words, the authorities should allow the recommended person to join the post of principal in the Abdul Hasib Higher Secondary School, Hojai. So he was allowed to stay as a principal there. Now, when that interim order was operating, Lordship, the education department came up with an IA and they prayed for vacation of that interim order, Lordship. That's at page 30. I'm reading from the beginning. The state respondents
Not
have
necessary. This earlier interim order was stayed by this order.
It was
1/9/2017.
Yes, Lordship. It was vacated basically.
Vacated or stayed?
Vacated, Lordship,
Last
because
last person. Paragraph number 6. Until next date, the court's interim order dated 21/7/2017 will remain stayed.
yes, Lordship, that was stayed, Lordship.
Hmm.
Lordship, the reason being that inquiry, Lordship, inquiry report, they said that he was entitled to, that's at paragraph 2, Lordship. The projection of the state's application is that the writ petitioner was awarded undeserved 0.5 marks in the leadership skills segment on the basis of incorrect information on the number of successful HSLC students of the school. If the correct figures are taken, the petitioner is entitled to only 3 marks in the leadership skills segment, whereas he was awarded 3.5 marks. So that was the reason, Lordship.
Thereafter, what happened?
Lordship, that was stayed, Lordship, that order, but he was not allowed to join probably as
So
principal.
the interim order is still operating.
No, Lordship, they withdrew that writ petition. They withdrew that writ petition in the meantime, Lordship.
Okay.
And on the pretext that, Lordship, he will be appointed probably, Lordship. Then against that order, Lordship, they preferred a contempt case also, Lordship. At page 32, Lordship will find what the court observed, Lordship, in that contempt case. Since he was not appointed as principal by then, he preferred this contempt case, Lordship. The contempt case was filed for violating the interim order of this court dated 21/7/2007 in WPC so-and-so. As the writ petition being WPC number 4304/2017 was closed on being withdrawn by the petitioner, therefore the contempt petition has become redundant and the same stands closed. So the contempt was closed due to the withdrawal, Lordship. Now subsequently, an order dated 8/3/2019 came up, Lordship. It's at page 33. It reads as, on recommendation of the State Selection Board Assam and in pursuance to the government approval accorded filed letter number so-and-so dated 8/3/2019 and subject to reversion without notice and without assigning any reason thereof, Abdul Rab, subject teacher of Abdul Hasif Higher Secondary School, Hojai, District Nagaon, is hereby appointed as principal on regular basis as posted in Abdul Hasif Higher Secondary School, Hojai. Now this order is under challenge in this writ petition, Lordship. Now the grounds of challenge, Lordship. The education department has also filed an affidavit, Lordship. Therein, there are two orders basically annexed, Lordship. That just go through it, Lordship.
Inspector of the school director. Affidavit.
Lordship, he was
Secondary
here.
education.
He was here otherwise, Lordship. He will come, Lordship.
Yes. Page number
page-
33 is the impugn order.
Yes, Lordship. Page 33. Lordship, in the affidavit filed by the Education Department, Lordship, at page 39, there is an order wherein, Lordship, this the inquiry which was conducted by Srimati Mamta Hojai was taken into consideration by the State Selection Board, and thereafter, Lordship, he he was awarded 11.1 marks against that leadership skill. It's at page 40, Lordship. This is by the State Selection Board, Lordship. The first one, Lordship, leadership skill 3.1 marks was granted. So this was done by the State Selection Board only, Lordship, because in the inquiry, he was granted only 3.0 marks, Lordship. Now here it was changed to 3.1 marks, Lordship. Now, my marks
No,
remains.
the question is whether the state selection board has the authority to grant such mark.
No, it cannot scrutinize, Lordship. It cannot scrutinize the applications, Lordship, preferred by the candidates before the school selection committee, Lordship. Under the rules, there is no such provision for the state selection board to scrutinize the applications, Lordship.
Okay.
And basing on that, Lordship, basically at page 42, serial number 2, the state selection board recommended the name of Abdul Rob for the post of principal, Abdul Hasib HS School. At serial number 2, the right-hand side column, Lordship, A, Faiz Muhammad Barbuya already appointed as principal in another school. B, Shankar Ranjal Pal recommended for National HS School Lamding. Now number C, Abdul Rob is recommended as regular principal of Abdul Hasib HS School Hojai. So that was recommended, Lordship, and that subsequently probably that order at page 33 came to be passed, Lordship. Now, my challenge to the order at page 33 is basically on 4 counts, Lordship. The first one is that, Lordship, in the application which Abdul Rab preferred before against the advertisement dated 18/6/2016. In that application, there under the rules, Lordship may kindly have a look at the rules, Lordship. If your Lordship peruses, it's page 377 of this book, Lordship. The Assam Secondary Education Provincialization Service Rule 2003.
$377.
Yes, Lordship, in this book, it's page 377. Rule 13, Lordship. Procedure of selection of principals. Number 1, before the end of each year, the member secretary of the school selection committee shall invite applications from the intending eligible candidates through an advertisement to be published at least in 2 widely circulated local newspapers. Number 2, on receipt of applications from the eligible candidates, the school selection committee constituted under Rule 8 within bracket 4, after scrutiny of the application. This is important, Lordship. The school selection committee constituted under Rule 8.4 shall, after scrutiny of the application, shall hold an interview and prepare a panel of names of 3 candidates on the basis of qualities such as leadership skills, administrative ability, integrity, and commanding personality. So I am basically now relying upon this Rule 13.2, Lordship.
13.2.
13.2. It says that the scrutiny is to be done by the school selection committee basing upon interview, and it shall prepare a panel of names, Lordship. Lordship, herein, admittedly, the applicant, that is Abdul Rab, preferred an application before the school selection committee in the interview, Lordship, wherein he gave a certain number of students which appear in the year 2015 and 2016 from that school, Lordship, and that number was taken on account to arrive at a percentage of marks which was given to him against that leadership skill, Lordship. Now that figure, which the number of students which he quoted in that application, Lordship, it is specific here, Lordship, on receipt of application from the eligible candidates. It says the application is from the eligible candidates, not from the principal of the school, Lordship. Now, herein in the inquiry report, it has been projected that it was given by the principal, Lordship. So it is not so, Lordship. It is the
No. Principal will, principal has to give the same on the basis of the information furnished by the applicant. He cannot generate the information on his own.
Yes, Lordship. That is not
And
denied.
moreover, you have not challenged the inquiry report.
I have not challenged it, Lordship, and I need not challenge it, Lordship, because that information which he gave in the before the school selection committee, Lordship, was not correct, Lordship, and due to that, at that moment itself, the application was liable to be cancelled, Lordship. But it was not done, and subsequently, without any authority, the inquiry was conducted, and the power to scrutinize the marks was given to the inquiry authority, as well as subsequently to that it was further manipulated, Lordship, by the state selection board. As it appears in the inquiry, it was 3.0 marks given, but in the state selection board later on, it was turned up that it was given as 3.1, Lordship. Due to that, Lordship, his marks were more than me, Lordship, 0.1 marks, Lordship. Now, Lordship, since those figures were not there in the application, Lordship, and those were subsequently entered by the inquiry officer or somebody else, Lordship, that will not be counted, Lordship. The initial application as it was, Lordship, that only has to be counted, Lordship, towards this selection, Lordship. Now, if there was a manipulation thereof, Lordship, and if it is found that it was manipulated, then, Lordship, that has to be rejected, Lordship, in my humble submission. That is one ground, Lordship.
Number two.
Number two is that, Lordship, the scrutiny that was done by the school state selection board under 13.2 cannot be allowed to be done, Lordship, because it does not have the power under the rules, Lordship, to scrutinize the application of the applicants as now, number three submission would be, Lordship, assuming that the inquiry was done but not admitting, Lordship, with authority, Lordship. I would say it was not done with any authority under the rules, Lordship. But assuming it was done with authority, Lordship, then 11 marks is to be assigned to both of the petitioner as well as the respondent number 5. Now, while doing so, Lordship, since they secure the same marks, Lordship, now what the respondent themselves did earlier was that, Lordship, it's at page 28, Lordship. Page 28.
Yes.
Lordship, at serial number 3 is with regard to the appointment of principal in Jain Memorial HS School, Agia, Lordship. Now, herein, the I'll read the whole. Peruse the report of Inspector of Schools dated 23/12/2016 and on examination of consolidated evaluation sheet furnished by the School Selection Committee, it is seen that Sri Biraj Chakraborty, who was recommended at position number 1 by the School Selection Committee, has already retired on 1/1/2017. Regarding position number 2 and 3, namely Muninder Chandra Das, assistant teacher, and Abdul Haq, assistant teacher, has got 11 marks each out of 15 and jointly ranked as second. It is seen that as per report of Inspector of Schools, Abdul Haq is senior to Muni Chandra Das and Abdul Haq is a good performing teacher. Further, Abdul Haq is graduate teacher and Muninder Chandra Das is craft teacher. Considering the matter in its entirety and the fact that Abdul Haq is senior to Muninder Das, therefore Abdul Haq is recommended for the post of principal. So it was based upon seniority. Now in this case also, Shankar Ranjan Pal is senior to Abdul Rablat. How? I'll show that lordship. In the page 14, lordship will kindly turn up.
Page number?
Page 14, 1-4.
1-4.
Page 14, against the column 8, lordship, teaching experience in a provincialized HS. Has your lordship got it? 8.
Serial number?
Serial number 1 is Shankar Ranjan Pal. He has 24 years of experience. And serial number 4 is Abdul Rab. He has 20 years of experience, lordship. So admittedly, this seniority is with the petitioner, lordship. So they ought to have, in terms of seniority, they ought to have appointed me as principal in terms of this, lordship. Now, lordship, another submission is there. It's with regard to the B.Ed degree, lordship. It's at, lordship will turn up to page 34 kindly once, lordship.
Yes.
Lordship, it's a joint complaint before the commissioner and secretary. It's dated 19/5/2017, lordship. I'll read that, lordship.
Not necessary.
Paragraph.
So, what happened thereafter? After lodging of this complaint?
Lordship, after lodging of this complaint, it was stated basically that the
No,
paragraph.
whether any inquiry was conducted?
No such inquiry, but
then,
lordship, the education department in its affidavit has stated that since I'll read that portion, lordship. At paragraph page 37, paragraph 11, lordship. That the deponent begs to state that the respondent number 5 wrote to the respondent number 4 stating that he had taken admission for B.Ed course in the Patharkandi College of Education under Assam University by taking permission from the then principal Abdul Hasif Higher Secondary School for increasing his teaching efficiency for the interest of students, but not for any service benefits. This is to be noted, lordship. Not for any service benefits. He took it like that only, lordship, without permission. So, since the college very pursued.
No, he obtained the degree.
Lordship.
With permission.
Without permission.
Without permission.
It was informed to the principal only, lordship, and.
Even then, his degree
there
is
no,
valid.
Nothing
degree.
in writing, lordship. There is nothing in writing. Lordship, the thing is that, lordship, the college where he pursued BA is 286 kilometers away from his college. No, now, lordship, that is not physically possible. If regular classes are being conducted and the course is to be pursued, he has to attend those classes, and without pursuing.
No, maybe you see, upon the complaint, no inquiry was conducted, no finding was recorded.
Nothing
And,
was recorded, but it was stated that it was not for service.
and,
Now, if it is not for
even then, the said degree cannot be said to be an invalid degree.
it's not
It's a valid degree.
Yes, Lordship, it's a valid degree otherwise. Now, with regard to that submission, that the figures which were given by the respondent number 5 before the school selection committee were later on changed. The Lordship, that fact, Lordship, not have been taken into the changing of the marks, the number figures was not to be taken into consideration. With regard to that, Lordship, I would like to submit one.
Who changed the marks?
Lordship, it was changed the marks because the inquiry was conducted, Lordship. And in the inquiry, it was found that, Lordship, in the year 2015, it was not 30 students, but lesser than that, Lordship. I'll just get that, Lordship. In the year 2015, against science stream, total numbers of students appeared was 23 when he submitted the application. Now, it was later on found in the inquiry that total number of students appeared was 30, Lordship. So 23 changed to 30. The percentage, passing percentage automatically changed from 56.5 for that year to 43.33. So that was in the inquiry. And in the year 2016, Lordship, in the art stream, before the school selection committee, it was stated that 83 students appeared, Lordship. But Lordship, herein, I had filed an affidavit wherein it is next, Lordship, at page 117, Lordship. Page 117. Page 117, Lordship will compare with it the inquiry report. Earlier, the Lordship, it was stated that 83 students appeared, and out of that 61 passed. So the percentage was 73.49. Now, there is a I preferred an RTI Lordship and application, and in that, Lordship, the in-charge principal replied, wherein it was stated at column number 6 of page 117, against the year 2016, Lordship, in the art stream, 88 students appeared, Lordship. And the pass percentage was 9.31. Now, they filed an affidavit yesterday, Lordship. In that affidavit, Annexer A, page 112, Lordship. They are distinguishing basically between the students who did not appear and who applied, Lordship. Annexer A, page 1112. It's dated 7/2/2026. This is by Abdul Rauf himself, Lordship.
Annexer 8.
Annexer A, capital A, page 112.
Yes.
Lordship, the first column, number of students applied for the exam, 88. Number of students appeared in the exam, 83. Number of students passed, 61. Remarks, 5 students had not appeared in the exam. So, Lordship, the percentage, there is a procedure how the exam is conducted, Lordship. Just prior to the exam, Lordship, a notification is floated by the board, and thereafter the students don't apply individually, Lordship. It's the school which applies on behalf of the students, Lordship. In that, once you apply for it, then you are enrolled, Lordship. Now, since the 88 students got enrolled for that examination, it has to be 88, Lordship. And the percentage is to be counted basing upon, Lordship, the total number of students, Lordship, who got enrolled, and not on the basis of the ones who appear, Lordship. Because they who do not appear, they are considered as failed, Lordship. And that has an impact upon the percentage of the ability or teaching ability of the teachers and the result of the school also, Lordship. They are treated as failed only, Lordship.
Okay. So these are the grounds upon which you have challenged the impugn order.
Lordship, I would like to say, Lordship, that since the appointment was bad, prima facie, Lordship, due to this number, Lordship, if it is considered minutely, then the percentage turns out that I secure, just one moment, Lordship. I would secure 11.00, I would secure 11.05, Lordship, if 88 is to be considered, and along with the 30, Lordship. The percentage turns out as 11.05, and in respect of Abdul Rauf, it turns out that the percentage is 11.0085, Lordship. So on this count, Lordship, I had secured more marks than him, apparently, Lordship. And Lordship, this order by which he was appointed seems to be bad, Lordship, and if that is set aside, Lordship, I have a reasonable expectation to be appointed as principal of Abdul Hasib School.
Okay. Okay.
And I'll rely upon paragraph 60 of the order that I've produced earlier, Lordship, with respect to that reasonable expectation. Legitimate expectation, sorry.
Okay. Yes, for the respondents.
Lord, I am for this thing. In petition number 4225 of 2019. On the last occasion, my lord, the petitioner side had paid for that to provide the affidavit in reply. That has been given by the petitioners to the affidavit of opposition filed by the respondent number 2. Now, in this particular case, my lord, on the last occasion, I have categorically submitted that whatever is the submissions of the petition and whatever the statements they have made in the writ petition of 4225 of 2019, that itself contradicts. And on the last occasion, they've hammered on the affidavit, para number 7 of the state respondent that has been filed by the respondent number 3. There, para 7, the state respondent have stated that the deponent begs to state that the process of selection of regular principal of National Higher Secondary School Lamding was made by following the Assam Secondary Education Provincial Service Rules 2003 as amended in 2012. However, prior to finalizing the selection procedure as new rule, that is Assam Secondary Provincialist School Service Rules 2018 came into force. So far as the matter is being sub judice before the Honorable Court, and moreover, the process of selection of regular principal in other provincialist higher secondary school has been initiated as per the new set of rules, that is Assam Secondary Education Provincialized Schools Service Rules 2018 as amended in 2021. Therefore, your deponent humbly prays before the Honorable Court to allow the deponent to withdraw the earlier selection process for the post of regular principal of National Higher Secondary School, Nagaon, and by advertisement number 221/6/2016 and further.
Okay, you are also supporting that contention.
Yes, because whatever they have replied, there is no denial of this fact. Only thing is that if it is new selection is adopted, in that case, his interest will be prejudiced. Only this one, and nothing.
Okay. Okay.
But they have not denied that the news, when this statutory law has been changed and it is to be implemented, why it should not be implemented? There is the affidavit in opposition of the affidavit in reply is totally silent. Because the statutory law must prevail. So in view of that, the writ petition number 4225 of 2019 has got no basis there. This is my respectful submission.
Lordship, my reply to this submission would be that, Lordship, the order at page 27, it's dated 8/5/2019, Lordship. This order validates the process which was undertaken by the authorities, Lordship. And thereby, it was continuing, Lordship.
Order dated?
It's order dated 8/5/2019, Lordship.
Annexure number?
It's annexure number 4, Lordship.
Okay.
So this has to come to a logical end, Lordship.
Okay. Yes, Mr. Datta, your stand is clear from your affidavit. So the authority may be allowed to undertake new process.
Adding to that logic, on last occasion, logic, my honest colleague had relied upon a judgment of partner by the state of Tripura logic to reinforce the argument that selection procedure cannot be changed in a midway. It was some substance of argument logic. Contrary to that logic, I just want to clarify. In that judgment logic, could the ratio of that judgment and the fact of those judgment is not applicable in our case because Honorable Supreme Court has held three aspects. That exercise was carried out under the Tripura State aforesaid lordship, TSRM. And in the midway lordship, after change of the political agent lordship, one new promotion policy lordship, NFR, came into introduced, whereby the interview system was abolished only on the written lordship. In that aspect, Supreme Court held on three counts lordship. First, Supreme Court held that you cannot change the rule by your office memorandum or executive instruction, as lordship was yesterday pointed out. I will bring to that judgment lordship. Second thing, lordship, in that case, lordship, entire selection was completed only at the stage of issuing the appointment letter. in Tripura case, Lordship. But in our case, Lordship, it was not the situation. It was still in the selection process, then another second tier of selection before the state defense committee was still to be carried out, Lordship. So, Lordship, that ratio, if Lordship has gone through the entire judgment, Lordship would see court primarily emphasize on the change of the interview or selection process by way of executive instruction. So that judgment does not hold the field so far as our case is concerned.
Okay. Okay.
Contrast, I have also shared the SEC copy to the court, Lordship.
That decision.
That decision, Lordship.
Okay, all right. I will go through the same.
Lordship, I may just point out that paragraph, Lordship.
You marked it in the decision.
Lordship, I'll mark and place, Lordship.
Okay.
Lordship, against this lordship, a short reply, lordship.
No.
Against this contention of my friend, lordship, my reply would be that, lordship, the 2018 rules would have effect prospectively, lordship, not
That
retrospectively.
is also dealt in the part of the case, Lordship.
Yes.
No, no. On the other day, you have pointed it out.
Yes, lordship. So this order, lordship, which I just pointed out,
We may clarify in the middle, in the same part, Lordship, that prospective operation has been dealt with in this part of the case which point understand line. Because in the paragraph 55 of the judgment as per this, the NFR was itself giving effect prospectively, new promotion policy. That's why courts hold that it should be prospective because it was the mandate of new promotion policy. So you cannot make it in
Okay.
Another difference I would like to point out, lordship.
The Supreme Court judgment which I am relying, it is clear and completely relied to our fact, Lordship. That's what, Lordship.
Lordship, another aspect I would like to draw your attention.
No. Please sit down. Let the other respondents complete their argument. Mr. Sodhuri, you were appearing for?
And again, from this number 5 will tell me this 2847.
R5. Yes.
Now, my first submission is that, my lord. The petitioner was recommended for a different school. I was recommended for a different school. Therefore, my lord, he challenge ought to have been confined to the, my lord, school where his name has been recommended. Because that recommendation stands, my lord, and the appointment has not been given. If your lordship comes to my affidavit in opposition at page 40 and 41.
Yes.
40, your lordship will find, my lord. This is a communication by the, my lord, director of secondary education to the commissioner. With reference to the subject criteria, I have been honored to say that the state selection board have deeply recommended 5 number of regular principals and 3 number of re-advertisement in the meeting held on so and so. Government is therefore requested to accord approval on the recommendation of the state selection board as stated above. Then page 41. Your lordship will find, my lord. Serial number 2, Logaon. Abdul Hakim Higher Secondary School. Now the petitioner, my lord, if your lordship comes to column number 5. B. Shankar Ranjan Pal recommended for National Higher Secondary School, Lavli. That is the petitioner, my lord. And so far as the respondent number 5 is concerned, Abdul Rob is recommended as regular principal or Abdul Hasid HL School, Bhojara. So, my lord, the state selection committee, my lord, the board has recommended him for a different school, and my lord, I have been recommended for a different school, and pursuant to that, my lord, I have been appointed.
And in the affidavit in the government, it is saying that is admitted that he has been recommended, but for some technical issues, his appointment could not be issued. That is the stand in the affidavit, right? That your worship will find in the affidavit of the government. Affidavit of the government, my lord, starts at page designation of the difficult cases. Internal sign of model files of 10 of the my lord government's director's affidavit.
Page 37.
I think that will be page 37. Yes, page 37. Prani page 37, internal page 3, paragraph 10.
Yes.
In fact, my dear worship, I also like to read paragraph 9. That the department begs to state that government by letter number such and such that 8/2019 approved the aforesaid recommendation of the state selection board on 12/2/2019, and accordingly, respondent number 5 was appointed as a regular principal of Abdul Hasib Higher Secondary School, Kodai, White Office Order number such and such 8/3/2009. Then paragraph 10, that the department begs to state that the petitioner has also been empaneled as serial number 1 of the merit list pertaining to appointment to the post of principal of National High School, Lamli, and the same has not been finalized by the government due to technical reason. That is my first submission, my lord. He has not abandoned his claim to that school also, and my lord, he is trying to get my job. Now, your worship has already noticed, my lord, the inquiry report has not been changed, my lord. There is a finding regarding, my lord, mismatch of the number provided. And, my lord, that mismatch on the basis of the principal of that school, my lord, at the relevant point of time, my lord, the inquiry report has said that action should be taken against the principal. Now, my lord, in the affidavit that we have filed yesterday, my lord, there we have given the, my lord, actual number, my lord. If your worship kindly takes up my affidavit, at page 112, your worship will find two affidavits, because here is also filed document. Against that, my lord, we have filed this reply. Now, if your worship takes up my affidavit, that is at my lord, page 112. Filed yesterday, my lord, it is connected.
Okay. Yes, sir.
Because he was harping on the number, my lord, whether 88 was the number of students they appeared, or my lord, it should be 83. On that, my lord, my learned friend was making some submission, my lord. Now, if your worship comes to page 112, your worship would find the results of the final examination 2016.
1 page number?
Page 112.
112. Yes, that is the result.
Yes, my lord. That is the result. And I'm the supporting documents also I have given my lord to that. Now, number of students applied for examination is 88. And that is the number he, my lord harping, he said that this should be the number which should be calculated for the purpose of making the assessment. That is the submission, man. And number of students who appeared in the examination is 83. Now, my learned friend says that the number of students who appeared is not material. Number of students who have applied, that is material. Whether they appear or not is not material. Now, my lord, in support of this, my lord, I have annexed the my lord document, the record of the school, and this has been, my lord, since I am the principal, my lord, and I have the records in support of the my lord, this statement, my lord, this record has been given. Now, in his affidavit, at my lord page 105 and 106. Your lordship may count, my lord. Your lordship got it, my lord. 106, your lordship will find this is what he is relying. That is the, my lord, earlier principal gave it which was, my lord, deprecated in the inquiry report. That inquiry report also, my lord, is no challenge. Now, your worship will see Abdul Hasib Higher Secondary School, serial number, my lord, column number 6. Number of students appeared. Is 88.
Page number, you were referring to page number?
Page 106.
106.
Your worship got it, my lord.
Yes.
Column number 6, your worship will find, my lord. Total number of students appeared is 88. Now, my lord, the word is this appeared. But I have, my lord, in page 1 or 2 and the supporting documents I have shown, my lord, from the records that 18 is the number of students applied and 83 is the number of students appeared. In page 106 also, my lord, they are considering the word, my lord, appeared. So that has to be the criteria. So according to the petitioner also, my lord, that is the criteria. Now it is a, my lord, word between appeared versus applying. So the report he is relying, my lord, which was found to be defective by the inquiry report, mismatch. They are also, my lord, the term if this appeared, not applied. This abstract your worship can be considered. This is my second submission, my lord. The third submission is that, my lord, the recommendation of the state selection board has not been challenged. The recommendation of the state selection board. Because on the basis of the recommendation and on approval of the, my lord, authorities, I have been appointed already. So recommendation of the state selection board is the foundation of my appointment and the, my lord, approval preceding it. That is not on the challenge. So without challenging in that, my lord, my appointment cannot be challenged. It's not not that, my lord, his case is not that he didn't have the report. Report is there, my lord, already. So that was not challenged. Therefore, my lord, on this count itself, my lord, the petition is liable to be dismissed. Now, recommendation of the my lord, state selection board is at page 38. Of my lord, our affidavit in opposition. The possible kinds peruse the, my lord, the recommendation. The matter relates to selection of principal of Abdul Hasib Higher Secondary School. Then, my lord, these the my lord, discussions have been given. The number of students 2015, 2016. That will come to page 39. Accordingly, the Abdul Rob, that is the rationale number 5, subject petition on recalculation considering both arts and science stream. The total marks awarded to him will be, the marks has been given, I see your my lord, more marks, 11.1 versus 11. This report is not challenged. My lord, the question, the my lord, one question came from your worship, whether my lord, state selection board can make the calculation, whether it is an authority. My lord, if your worship kindly peruse the rules. My learned friend was reading 2020 rules.
2003 rules.
The 2000, my lord, 20 rules is also, my lord, very clear. 2003 rules to understand.
So page 377 it is. 377.
13 is the, my lord, procedure for selection of principal,
Page number
page 377.
377, yes.
Subsequently, on the 2020 rules have come forth, my lord, at the point of time when the selection took place, 2003 rules were enforced.
Rule number 13.
Rule 13, my lord. That is, my lord, my learned friend has read a portion of it regarding the, my lord, selection by the school selection committee. Now, rule 13, sub-rule, uh, four, my lord. Rule 3, sub-rule 3, my lord, the panel of names so prepared by the school selection committee shall be forwarded through the concerned inspector of schools to the state selection board constituted under Rule 16. Then sub-rule 4, after receipt of the panel under sub-rule 3, the state selection board shall prepare a select list equal to the number of vacancies, taking into consideration such leadership skills, administrative ability, integrity, and commanding personality. The panel of names so prepared and recommended by the state selection board shall be submitted to the government, which may, after causing such verification as may be deemed necessary, shall accord approval for appointment. So, my lord, a duty is cast on the state selection board. It has to be scrutinized. The state selection board shall prepare a select list taking into consideration, my lord, these factors. Therefore, my lord, after the school selection committee recommends the name, my lord, it is the state selection board, my lord, which will make the, my lord, assessment. And on that basis, my lord, it will send it to the government for approval. And on approval, my lord, one has to be appointed. But this, my lord, selection committee's recommendation is not under challenge. And selection committee has, my lord, said that I secured, my lord, more marks than the.
Okay.
Now, my lord, another aspect that also came to your worship's notice, my lord, he obtained his BA degree by impersonation. And there is my lord, there is a report to that effect, my lord. That is at, my lord, page annex 22 of our affidavit in opposition, page 14, page 49, my lord. Annex 22, page will be a little different, my lord, annex 22.
Page number 40.
My lord, in my affidavit it is 49, but then, my lord, annex 22. I could not verify, my lord, some designations are different.
There are a lot of difference.
Yes, sir.
It is very difficult to find it out.
My lord. I'm sorry, my lord, we also could not access properly because we did not verify.
Your first affidavit or second affidavit?
First affidavit.
First affidavit.
It is annex 22. Tomato the number.
So 93.
It can be, my lord, perhaps 93.
Page number.
Annex 22. The communication dated 9/8/2012.
Yes.
By the inspector of schools to the director. May I read it, my lord? Subject: inquiry report regarding B.Ed degree of Sri Shankaranjan Pal, the repetition. Subject: teacher, public HS school, Lonka. With reference to the subject cited, I have the honor to submit here the following report. Then, my lord, serial number 1, that sir, Sri Shankaranjan Pal, ST, that is subject teacher, appeared at B.Ed examination in 1997 and passed the same as per mark sheet submitted. The examination program for B.Ed exam for the year 1997 collected from Gauhati University. The examination started with effect from 18/6/1997 and during the exam on 23rd and 25th June, that is for exam in paper 3 and 4, Sri Shankaranjan Pal present in the school on those 2 days from 9:15 AM to 3:15 AM, which has been found correct, as I have personally verified the teacher attendance register of the school on my inquiry regarding the matters of anomalies done by Sri Sankaranjan Pal. In this connection, it is assumed that the other person appeared in the examination hall for those days. No departmental permission for undergoing BA examination taken either from the inspector of schools nor from the director by Sri Sankaranjan Pal. He failed to submit departmental permission copy for undergoing BA in spite of notifying him repeatedly as letter number such and such, dated 37/2012. On verification of his service record, it is found that he did not take any legal leave during the examination period and even during taking practical classes. That he has been drawing beard increment. Now, my lord, as your worship has, my lord, observed, he maybe, my lord, in this school, but the fact remains that he has obtained a, my lord, degree. Whether the degree will be valid or not, that is a question, my lord. But then, my lord, even if the degree is valid, my lord, the conduct of the petitioner has to, my lord, has a rule, my lord. He has not done everything in my lord clean hands. He was, my lord, working in two schools at the same point of time. On this conduct, my lord, he is not with clean hands. That is my submission, my lord. And therefore, my lord, having not challenged the inquiry report, having not challenged the recommendation of the state selection, we shall got the authority to, my lord, scrutinize and again verify the mark. His reputation is, my lord, half-baked, and therefore, my lord, it is liable to be tested. I have already been appointed on recommendation of the selection board, state selection board approved by the matter of authority. And I'm working. That will be the condition.
Yes, Sarma, any reply?
Lordship, Lordship, my senior firstly said that Lordship, since he applied in and was recommended against, since the petitioner was applied and recommended against another school by the state selection board, so he could not have challenged the appointment of the respondent number 5, Lordship. Now, Lordship, herein, he applied separately for both the schools, Lordship, and the rules are applicable equally in both the cases, Lordship. So that cannot be distinguished in this manner, Lordship. Now, my reply would be that, Lordship, since he applied separately and his candidature was all through valid, Lordship, so that question need not have come, Lordship, whether his recommendation against another school is valid or not. Lordship, that question doesn't come, Lordship. His candidature was never cancelled at any point of time, Lordship. That is the submission, basic submission, Lordship. Please, 37.
Any other reply?
Lordship, yes. Lordship, at page 37 of my senior's affidavit, he relied basically upon the inquiry report. Therein, he said that it was not put to challenge, Lordship. This inquiry report, Lordship, is against the law, Lordship, I would say. So, against the law means, Lordship, there is a clear procedure prescribed under the rules, Lordship, how the selection is to be conducted, Lordship. Adopting any means dehones the rules, Lordship, is illegality, Lordship, and that's what Lordship would not allow to be perpetuated, Lordship. So this inquiry report is illegal prima facie, and challenge to this, Lordship, since it
Okay, you have already submitted on this point.
Yes, Lordship.
Don't,
And,
do not repeat the same thing again.
Yes, Lordship. Another thing, Lordship, page 93.
Third submission to the recommendation of the
The recommendation of the State selection board was also not put to challenge. That was my senior submission. I have the same submission with regard to this also. And another thing, Lordship, since the order by which the respondent number 5 was put to challenge, that's order dated 8/3/2019. It was put to challenge, Lordship, in this writ petition. Since this is under challenge, all the process undertaken in the interim to come at this end, Lordship, is illegal, Lordship, in my humble submission. The process, and it need not be challenged, Lordship. These are consequential, Lordship. Since the main order is under challenge, these consequential orders are need not be challenged, Lordship. That's the submission. And with regard to my B.Ed, Lordship, my B.Ed, there was evening classes, Lordship, and it was done through evening classes.
Where the examination was conducted?
Lordship?
Examination
Yes,
was
yes,
held
I cleared everything, Lordship, and there is no, my B.Ed, Lordship, although he has questioned, Lordship, with regard to my B.Ed degree, in the affidavit, it's by way of an affidavit only, and it was never challenged in any writ petition or anything like that, Lordship. Now, since he said that I did not appear in the classes, Lordship, I would say
the inquiry conducted by the inspector of school
Lordship,
reveals that on the date of examination, you remain present in the school.
yes, in the reply.
How can you remain present in two places at the same point of time on the
yes,
same day?
In the reply, I have stated.
Is it your case that the examination was conducted during evening hours or night hours?
No.
Then?
No, but then, Lordship, I had it was during the that vacation period, Lordship.
Vacation period on that day, as per report of the inspector, the school was open. He has checked the attendance register.
I have written it. Lordship, now with regard to that 88 or 83, Lordship.
No, already you have submitted on that point.
Yes, I would like to say, Lordship, that this annexer, Lordship, I'd like to show once again, Lordship, this annexer. It's at page 16A, Lordship. Page 15, Lordship, will see it's an extracted type copy. This is the office memorandum basis upon which the marks are to be allotted, Lordship. Now, against
Annexer 2.
Yes, Lordship, Annexer 2. Annexer 2. Leadership skill, 5 marks is granted for that. Based on the result of HSLC, AMH, HSSLC of the current year 2016 and last year 2015 of the school in which the person is working at present. Now, the result herein is clear, Lordship. The candidates who does not appear is treated as failed, Lordship. They do not pass, Lordship. So, the failed candidates, they are to be counted, Lordship. They cannot be ignored, Lordship. And if that is counted, I have already pointed out, Lordship, what the percentage is, Lordship. Now, Lordship, with regard to my first submission, I would like to point out a judgment, the Honorable Apex Court, Lordship. To copy the letter now. Lordship, herein the candidature, basically what had happened, it was before the High Court of Punjab, and subsequently it went on to the Supreme Court, Lordship. What High Court had done was that the respondent number 1 applied against the post of BDS course, Lordship, and therein, Lordship, she did not claim against the backward class quota, Lordship, initially while applying, Lordship. Subsequently, she gave a certificate before the authorities after the applications were submitted. That is at paragraph 3, Lordship. The High Court, by the impugn order, having taken note of the fact that the respondent number 1 had not submitted any certificate along with the admission form and claimed to have forwarded the same letter, which did not reach the competent authority before the prescribed date, still directed that respondent number 1 be admitted against the said seat, which had become vacant on compassionate ground, treating her to be belonging to backward area. In respect to the respondent number 2, as already mentioned above, the High Court directed that a seat be created for her admission. Having issued the direction aforesaid, the learned judges observed that the admission of the respondents should not be treated as a precedent because the direction had to be issued for the admission in view of the peculiar facts of the case. Now, Lordship, the state took a stand that there was only one vacancy which arose due to leaving of the course by one Sanjeev Goel. And at paragraph 8, Lordship, what the observations were is there, Lordship.
Okay.
Lordship,
I will go to
paragraph
the-
8 and 9 are 11, Lordship. The observation, it was stated that basically the respondent number 1 could not have been appointed against that quota since it was not at the time of admission she submitted the certificate.
Okay. I
And
will
against
go to
that
the-
post, the respondent number 2 was appointed, Lordship.
Okay. Mr. Dotto, you are here? You have filed your affidavit here?
Yes, sir. Lordship, in this case, we have filed affidavit.
Okay. Okay. Heard Mr. MP Sharma, learned counsel in WPC number 2847 of 2019. Learned counsel for the petitioner. Mr. Dotto, learned standing counsel for the secondary education department. And Mr. Alam for the respondent number. Mr. Alam, you are for the respondent number? Respondent number 8. And Ms. Nandi is not here. Not here. Argument concluded, judgment reserved. In WPC number 4225, heard Mr. MP Sharma, learned counsel for the petitioner. Mr. Nandi for the respondent number. Respondent number 5, Mr. Dotto, learned standing counsel for the secondary education department. Argument concluded, judgment reserved.
Obliged, Lordship.
Number 49.
Lordship, this is the regular first appeal, Lordship.
Yeah.
The court below has dismissed allowed the petition under Order 7 Rule 11 and dismissed my suit. So it's a regular first appeal on the ground that I am barred by the SARFAESI Act and the Recovery of Debts Act. When it's not so, because I have not challenged anything under the SARFAESI Act. With the proceedings before the DRT went on, in fact, my loan has also been settled on a one-time settlement. What I'm questioning, the functioning of the bank. That is what was questioned in my title suit. So the learned court below, without going into it, on a plain reading, the SARFAESI matter under the SARFAESI Act is pending, rejected my claim. So it's a regular appeal, Lordship. I don't even have a prayer for stay.
When the decree was passed?
Decree was passed 10-3 on 10-3, Lordship.
10-3.
Yeah.
Is it part of the record?
Lordship?
Is it part of the record?
Yes, this is a one-line order, Lordship. This is just a one-line order at page 121. In view of the order of Miss J case number this, the case rejecting the plaint, allowing the petition under Order 7, Rule 11, D of the CPC as prayed for by the petitioner, considering the same, the title suit is dismissed.
No, whether the decree was drawn up.
So decree has not been drawn up as yet, but I can't wait, Lordship. And nowadays, it's not mandatory. Courts have held that even without the decree being drawn up, I can come on an appeal. Because sometimes decrees, they get very delayed in drawing up, and my time period will elapse.
No, maybe. But you see, this section 96 and
Yes.
order 41 rule 1
Yes.
against the decree.
Yes, Lordship, but this automatically, the decree will be dismissing the suit. Dismissal of the suit. What has happened, the effect, there will be a decree decreeing the suit against me. But that decree has not been drawn up by the court as yet. So if I wait, my limitation will go. So courts have held that even without the formal decree, with the order and the judgment, I can come on a RFA. That has been held. Lordship. Definition of decree in section shall be deemed to rejection of a plaint is also a decree. But the decree has to be drawn up. Huh? So decree has not been drawn up as such.
No, if the provision is against the decree, original decree, then without the decree, can we entertain the appeal?
Yes, Lordship, we can, because the decree is only a formality. Because rejection of plaint under section 2(2) is also a decree.
No, therefore, the trial court has to draw up a decree.
No, the lower court has to draw up a decree, but sometimes it so happens that the decree is not drawn up. There's delay in drawing up because
No, maybe.
but then my limitation will go.
No, limitation, you have to file an application for condonation of
But
delay.
limitation will be from the date of the judgment, Lordship.
No, that's all right, but
Lordship, I will place, because this has been passed by the office also. I will just place before your Lordship, there are decisions where you don't have to wait for the decree.
okay, then you produce it by tomorrow then?
Friday, Lordship.
Friday.
Yes.
Okay. After hearing learned, after hearing Ms. Hazurika, learned senior counsel assisted by Ms. So-and-so, it is provided that recessal is the matter on Friday
Friday
at 2 p.m.
Okay.